has to attend the case, my lord, in Mumbai court. He has to attend Bangalore court. He will be escorted with the police. My lord, it is almost to curtailing his liberty. He will be, in all purpose, my lord, practically, it is a prison, it is. And his liberty is curtailed. And my lord, such a provision, my lord, without having an opportunity.
Cases.
No opportunity was given in this case, which I refer to. And they would say it is not a detention, it's not arrest or detention. It is a restriction order.
No, how would he be sent? How would he be taken to those, cases which are pending in Bombay? And
That he can request and we will
will make
allow
a
that. Yes, all those things are permitted.
My lord, if
Escort is there.
they, my lord, if they allow him to go by himself,
Escort.
to attend court here and
But tell
Mumbai,
us, Mr. Pasha.
BC is there.
1 minute.
there is.
Mr. Pasha, it is not an extreme proposition. The purpose of this act and the section 3 is confining you to a center is so that if there is no case, fine. But the day of deportation come, you will be from the center, you will be sent back to your
Yes,
country.
yes, my lord, till
But
then. Yes.
if you are allowed to come out and suppose you go missing, is it not the very purpose gets defeated?
My lord, even if he is missing, my lord, he cannot go out of country without a passport and visa.
Obviously, you have been staying in the country, that will serve your purpose.
My lord, here there is no purpose, your lordship, except that there is no other purpose here.
That's the
He has
reason we
come-
have asked you what
He's, lordship,
what made you stay from 15 to 20.
Lord, your lordship may kindly, regarding that fact is concerned, the information can be given only by detaining. He is in center. We could not get any information. Therefore, I
It's all
request,
right.
my lord, that he may be produced physically. My lord, he will explain before your lordship why he was. That is, my lord, that we don't get any information from anyone.
What are the other judgments you are relying upon?
My lord, the other judgments, your lordship, in respect of foreigner only, kindly see page 23, my lord. Delhi High
Yes,
Court has
23.
considered.
Let's see 23.
Yes. My lord, the Charles Kinsley, my lord, kindly paragraph 10, my lord, it is.
See, this was in the context, Mr. Pasha, a criminal case, sentenced undergone.
Yes, that's,
Still he is being continued.
yes.
And that's right. Then it is violating sentence because ultimately their case is the moment criminal case is over, we'll send him.
Yes.
Despite that case being over, despite he has undergone the sentence, he was being continued. That the court said this amounts to unlawful detention.
My lord, in those cases, my lord, but in case of an under trial is concerned, my lord, unless he is proved guilty for offence under section 14 of Foreigners Act, the provisions of section 3E cannot be invoked. Here, my lord, this, my lord, restriction, my lord, that restriction cannot be imposed.
Very right. Section 14 is the charging provision.
Section 14 is the charging provision, but my lord, till it is established that he is guilty of that offence, my lord, Foreigners Act section 3E cannot be invoked. This is my submission because section 5 says whenever a criminal charge is made against a foreigner, my lord, he cannot be deported. He cannot be allowed to go out of country. And my lord, he should have an opportunity to defend himself.
That's right.
Till then, my lord, the law presumes him that he is innocent. My lord, once he is found guilty, my lord, that and sentenced, he will be confined. My lord, after serving sentence, my lord, if he comes out, they have the authority to restrict his movement, to deport him to his country.
Then tell us one thing.
Please.
If this is the submission you are making, are you saying this, that without there is a final conclusion under section 14,
Yes.
he can't be confined to the center?
Yes, that is the meaning of Frank Victor's case of Supreme Court, my lord.
Just 1 minute.
Yes.
But this order bail order gives them the permission to pass an order under 3(2).
My lord, only they have been given permission, my lord, to inform the respondent regarding this.
That's right.
And my lord, the detention in deportation center is rejected. Kindly see, my lord, that order it is. Their prayer was considered by the single judge. Detention in deportation center was rejected.
See, now it's open for the respondent to move the registration officer appointed under 3 of the foreigners rules. If this is the proposition you are advancing, then this would be contrary to what you are arguing.
Lord, the
That
position of
means
law.
that means they can't invoke rule 3 also.
Yes, yes. My lord, rule 3 also cannot be invoked. Lordship, kindly in that order, my lord, paragraph 12 and 13, my lord. Their
Yes.
contention, my lord, all these contentions was considered.
Which paragraph?
My lord, paragraph 5.1, your lordship. 5.5, my lord, paragraph 5, your lordship, kindly. A coordinate bench of this court in criminal petition so had issued guidelines stating that as soon as the offence under Foreigners Act and other laws is detected, and there is a strong primary material to show that the
Yes.
detected person is the foreign national. And my lord, that their contention, my lord, was not given. The benefit was not given. The prayer was rejected in this case. And my
We have
lord,
seen
he
that.
was allowed to go out. He was allowed to go out by for the purpose of executing bond. My lord, they have been given, my lord, only a permission to inform the concerned authority. My lord, that now whether the foreigner the registration officer can pass an order under section 3(2)(e). My submission, my lord, that can be only after he is found guilty, because the decision of Supreme Court, my lord, if he is involved in the commission of offence under section 14, should mean that he should be found guilty. Otherwise, my lord, the decision of Supreme Court comes to his rescue, that he cannot be detained.
Okay, thank you.
The
Yes, we have heard you, Mr. Pasha now.
please,
Reserve.
please.
Right, just keep it. Next man. Okay. We have reserved it, Mr.
Great.
Yes. Which is that? Give it to me.
Number 2. ABS Babu. List number 2, Shri Babu DR.
Counsel here. Srimati. Who is only one set. Is not served around the What are your instructions, Mr. Bilyappa?
My lord, there was a NCR, non-cognizable report pending against the alleged detainee. That was registered and there was no detention. So therefore, there is no detention.
He is now not inside.
No. Case and counter, which was registered as non-cognizable report, and they were not registered. I mean, they were not detained or taken into custody, since it is non-cognizable.
We'll just pass over. Let's
Yes,
see, possibly
yes,
the
yes.
council will come. Yes, ma'am.
Serial number 6. Serial number 6, Shri Nataraj.
Raise short accommodation.
Just say that office objection be cleared within 6 weeks.
7. Serial number 7, Shri Vivek.
Office objections be cleared within 6 weeks. Oh, dismissed. Which I didn't know. CN Sri Kumar appeared.
Proceedings 66.
Then,
It is since
23/4 is day after.
case is pending for this.
How many matters are there? Around 24, 25, according to our diary.
More than 15.
Supreme Court has dismissed.
You have seen that?
Please, no.
23rd. अच्छा पास हुआ. Let's see.
7 pass. Serial number 8. Shri Mahabaleshwar.
The petitioner is in the case, madam.
मेरा और कुछ है.
Serial number 8.
6 weeks time,
पास
my
हुआ
lords.
ना? Yes,
6 weeks time, my lords.
6 weeks are granted to remove the office objection.
9/7. Serial number 9.
6 weeks are granted.
9/7.
Remove the.
Serial number 10. Shri Ravi Shankar. 10.
Applying to Lordship. I have taken steps to implementing application.
This is impleadment application for
Impleading
respondent number 5.
Official liquidator.
But there is no, the service has not been effected.
This is not service. Lordship.
Just say that service on proposed respondent.
Yes, yes, Lordship.
Proposed respondent is still incomplete. Let fresh notice be issued
Yes,
for
yes.
service on
I will take steps.
respondent number
Lordship.
5.
Much obligation.
14/7. Serial number 11. Shri Mahesh.
Interim order may be continued.
Interim order, if any, to continue.
For
Just check up. now.
number 1.
Check up.
Fulfilling this respondent number 2 to 4, your lordship.
Yes, 11.
Well, paper books are all filed, my lord. The office note there, my lord, is with respect to non-filing of paper book by the R1. My lord, earlier there was an order, my lord, for asking the R1 also to file the paper book, but that requirement may not be dispensed now because I've already filed and they're in agreement with what I have filed.
Who appears for R1?
R1.
My lords, I
You have
appear
seen-
for
you
the,
got that paper book?
Yes, my lords. My lords, counsel is appearing through VC, my lord. Arguing
There's also a counsel online. my lord.
my lords,
Yes.
I appear for the first respondent, my lords. Sorry, my lords,
Yes.
I'm from Chennai. My lords, all the pleadings have been completed, my lords. We are ready for final arguments. It's a very short issue, my lords. If you lord, it's a 2009 suit, my lords, where it was ordered in 2021, my lords, and everything. There's only one issue they have taken, my lords, as regards privity of contract is the only defense. That all the documents have been admitted by them, so that issue is only, I guess, my lords, only issue to be argued. If your lordship
Yes.
can give us a short accommodation, my lords, I won't take more than half.
Just
half an
say
hour
this,
subject to-
paper books have been filed by the counsel for the appellant. Full stop. In view of the fact that paper books have been already filed, comma, the filing of the paper book by the counsel for the respondent number 1 is dispensed with. Full stop. List the appeal for hearing on.
Can I request a shorter date, my lords?
We'll give you just now, give you a
My
normal.
lord, also I've deposited the bank guarantee, my lord, in terms of the interim order that the court had granted. On 15th of June, my lord, there's an interim order of stay that is granted. And I've also deposited the bank guarantees.
But
Those
that
are
order
also,
must say so, the bank guarantee would continue to operate, huh?
yes, my lord.
Yes.
It is reflecting in the order, cause list. If that's
That's right.
also, yeah. So if that could also be noted, my lord, and then matter posted for hearing, my lord, otherwise it'll keep coming up for orders.
So what do you
except-
want?
It could just say, my lord, that the matter may be listed for final hearing, my lord.
Final argument.
Because
No, interim order to be continued.
My lord, that interim order was not a date to date, my lord. It was like an absolute order. It was
Yeah,
granted.
absolute. No?
On 15th of June, my lord, 2022, it was granted.
Yes.
Any specific date, my lords?
12th of July.
Any time in the June, my lords?
14th
Subject
July,
to,
sorry.
14/7, sir, 14/7.
is it possible in June, my lords? Subject to, just request, my lords.
Pardon?
Can we have it in the second week of June or third week of June, my lords?
No, not possible. You know, we have already many matters there. Next.
Till number 12,
Obliged.
should we just 12,
This will not deposit. None for the appellant, re-notify.
16/7. Serial number 13.
I appear on behalf of the respondent, my lords. My lords had directed that written arguments along with judgments be filed. I
Yes.
seek 1 week's time to do the same, my lords.
Written submissions be filed within 6 weeks.
8/7. Serial number 14. 14.
I'm appearing for appellant, my lord. There are several litigations between these parties, my lord. There is a talks of settlement going on between the parties. Your lordship may have this matter after vacation. We'll report settlement, my lord.
Who appears for the other side?
Mr. Santosh Narayan.
Tosh Narayan.
At the
Yes, madam.
request of counsel for the appellant, re-notify all.
16/7.
Grateful, my lord.
Serial number 15. Srimati Kavita.
Let fresh notice be issued for service on the respondent returnable on.
17/7. Serial number 16. Shrikant.
Your first statement.
Let fresh notice be
Respondent
issued.
number 1 and 2, your lordship.
He is a respondent representing in 15.1. You appear for whom, ma'am?
16, your lordship. Serial number 16.
Pardon?
In serial number 16, your lordship.
No, there is 15.1. Ma'am, 15.1.
No, I apologize. This is 16.
Okay, say. Notice.
16.
Yes.
We have engaged a senior counsel in this matter. Request for a pass.
16, your first
We have engaged
statement.
a senior counsel in this matter. Appear for respondent number 1 and 2. We request for a pass over, your lordship.
Land tribunal order is
Pass
challenged.
over. Let's see. 17.
17.
I appear for the appellant, your lords. Lords, there is an attachment order now in vain. The suit is for recovery of the amount under the letter of credit, your lords.
Yes.
In fact, there is an attachment warrant that has been issued now.
Attachment of
Movables, your lords.
removables.
It's a,
When copy is not serving, the file objections in that regard, madam. Respect of IA first stay.
No, which
The
IA?
respondent number 1, madam.
Which IA you are referring to?
IA first stay, madam, please.
IF for stay was filed along with the paper book
What
therein.
was the file, ma'am? इसमें order से नहीं आ रहे.
The first respondent here had given a letter of credit, your lords.
It's a fresh matter. Who appears for respondent number 2?
I am for respondent number 1, madam.
Has not entered appearance, your lords. I have taken summons to 3 times, your lords.
But and anyone appearing for So why don't you serve respondent number 2?
He's not appeared before the court below also.
He didn't appear.
He was placed ex parte therein, your lords.
But in any case, you have to complete the formality.
Please, your lords, now what has happened meanwhile, lords, with a financial institution there. Now they have got an attachment warrant to that effect, your lords. I'm also making, please, your lords. An attachment warrant has been served.
Has it been executed?
Yes, it has been executed therein, your lords.
Okay.
We have made an application to postpone it till the appeal is decided, but that was negatived there before the court below, your lords.
Just show us what kind of a movables have been attached.
Your lords, banking, what they only want to recover, please, your lords.
Then you just show us the attachment order.
Copy is not served to me, my lord.
It's a financial institution there in the lords bank now. On 21 Rule 26, read with the cure, the court has also a decree been sent for execution, such sufficient cause has been.
Postbox. I'm surprised. Where are you situated? This respondent number 1?
Please. Actual address is that, my lord, in that
You
petition.
appear for respondent
Yes,
number,
I'm for the respondent number 1. Respondent number 2, I don't know, my lord.
no, respondent number 1.
My lord, please. K is real. my lord.
It's Bangalore, your lords.
No, we want to know what have been attached. Between one and to me, between the bank and the Balaji.
PF paid reissue attachment of warrant. Sir, hence IA number 2 is rejected. Reissue attachment warrant against JDR number 1, that is the appellant land. As per the address mentioned in the process memo, PF is paid, reissue so and so. JDR number 2 as per the address mentioned in the cost title.
My lord, 1 week time may be granted to file the objections, my lord, in respect of this memorandum.
No, but tell us one thing, there is a money decree against you. You deposit.
Please, your lords, even the money decree, your lords, I was not liable to pay. It was the third respondent there in your lords, kindly.
Now, what was the contract about?
It was a letter of credit, your lords.
Okay.
Please, your lords, the first respondent had opened a letter of credit. Under the letter of credit and the invoices raised by the third respondent, I had to pay. I have no option but to pay the amount. It's like a bank guarantee, your lords. In fact, the third respondent called upon us to pay the said amount. We had to pay. The first respondent contended that we have already paid. Please don't pay that amount. When a third respondent has demanded the payment, I had no option but to pay the amount under the letter of credit, your lords. Your lords may kindly go at page 40 of my paper book, your lords.
No, but third respondent is Bank of Maharashtra.
It's a Bank of Maharashtra.
No, but the
R2 maintains an account with.
Who is the beneficiary under the letter of credit?
R2.
The Balaji.
Balaji.
And okay.
R2 is a beneficiary, your lords. He maintains an account to the third respondent. Invoices were given to the third respondent to recover the amount under the letter of credit now. Third respondent has called upon the first respondent to pay the amount at the appellation. Accordingly, the bank has paid the amount. In fact, your lord, there is a responsibility upon me to encash the letter under bill of exchange, your lords.
And the respondent number 1 went to the trial court,
Yes.
filed a recovery,
Yes.
Filed a suit for it,
including you.
including me, your lords.
And okay. Was it proved that the payment was made? Was it proved the payment has been made?
Payment was made, your lords, the moment was the demand, the third respondent before your lords did not contest the proceedings also. He also kept himself away from the court.
Oh,
Please, your lords. Second and the third respondents, keep them away. And as a bond, I'm bound to pay the amount in the letter of credit.
Between A and B supplier goes to A. जैसे बस reach होगा. Letter of credit will be invoked and B will release the money to the seller. लेटर ऑफ क्रेडिट रिवोक नहीं करना, मैंने उसको ए को पैसे दे दिया है, दे दिया बैंक this thing will move credit is revoked by a seller to I have to pay to A. हो गया, बी को पैसे दे दिया और बैंक ने पैसे दे दिया. He doesn't appear. Who will vouch to bring पैसे दे दिया?
Under UCPD 600, your lords, the moment they claim the amount, I'm bound to pay the amount therein.
just tell us,
Malad.
is this respondent number one a government entity?
Yes, Malad.
It's a government-
Undertaking, Malad.
It's an undertaking.
Please.
Now, did you receive the amount from this respondent number two?
Malad, I'll take instruction and file the objections. Can you have it on Monday, Malad? 28, I'll file
Yes,
the
sir.
objections.
Is
on
it your
28.
case? Or was it represented to you by respondent number two
Please, your lords.
or by them that they have already, the money has already been paid?
No, they have not been represented. That
It was not.
not. Even if your lords, if they are represented, the third respondent being a government of India undertaking that, Bank of Maharashtra. They had asked, they made a complaint to the Reserve Bank of India also, contending that I did not make a payment under the UCPD 600. The Reserve Bank of India also directed us to pay the amount to them under the UCPD 600.
Oh,
Please, your lords, that is what the contentions, whole contentions are there before the court now.
now when they went,
Regulation, regulator, RBI is the regulator there. They forced us to pay that amount there.
okay.
You see, R2 doesn't appear before the court. He does not say that I have received the amount. Under the bill of exchange,
What were the preconditions that were to be followed for the release of the?
submission of the bills, your lords, what is contemplated under this UCPD 600. I have nothing to pay. I have only to pay the amount whenever it is raised. What they wanted to contend before the court, before the court below, that the goods, until the goods are received, I should not make the payment. Under Article 13 and 14 of the UCPD 600, your lords, I am not bound by the, whether the goods are there or not received. I am bound by the documents, bills, your lords. The bills were sent to us.
Was the release of the amount after the letter of credit expired?
Yes, Malad.
It was not so, your lords.
So there is a finding of fact.
There's a
against you.
finding that the letter of credit, that the letter of credit had expired, your lords.
If it expired, the liability was fastened on you.
Then it was not expired. The court did not look, that document was not produced by them. They're in the lords now.
Page number 20.
There is another matter wherein your lords, wherein I had succeeded. Same letter of credit.
What are the movables which have been attached?
That's a banking financial institution today. We'll have.
We want to know what have been
They have not-
attached.
Computer, table, chairs and other.
No, how, from which order, how do we get it? You see, this order, it's only an issuance of summons for attachment.
Correct, lords, the list of movables have been furnished by them.
Huh.
Taking along with the process memo, along with the computer, tables, other things now.
Has that attachment been executed?
Now they had executed, they had postponed it. Now again, now you launch,
They have postponed it.
they have not now it is matter stated to be on 24th.
No, we are just asking you, has the attachment been executed?
They have attempted it, lords.
Pardon?
They had attempted the first instance.
They-
They had gone to the wrong
They have gone to the another branch, a wrong branch they had gone.
So today there is no effective attachment.
Now an order has been passed, your lords, please your lords may kindly see. Hence IA2 is, please your lords may kindly see. Under these circumstances, IA2 is not maintained. Hence IA2 is rejected. Issue attachment warrant of movables against JDR number 1.
So this is issuance stage, but has it been executed?
Yes, they will execute it, your lords. They have.
We are asking you a very specific, has it been executed or not?
Till
Not.
previous date was executed.
What about your instructions?
That's why.
You
kindly
do
have
one
them
thing,
print.
ma'am, if till the next date,
My lord.
you have not executed till date,
No,
you will
my lord.
not execute it tomorrow.
I'll take instructions.
Yeah, we will say so you want. We don't want at the back, you go and execute it. So ultimately a banking company, it's a scheduled bank. Government, very well. Just say this.
28, my lord, I'll file the objection.
Respondent, just 1 minute.
And,
Respondent number 2 is still unserved. Let fresh notice be issued you.
Please, your lords.
Let fresh notice, including hand summons,
And
be issued for service on respondent number 2. The learner can't, just say this is an early hearing, now. Early hearing application, 1 of 25. For the reasons stated in the application, comma, the IA 1 of 2023 has been taken for consideration.
One submission, my lord, sorry. Subject to deposit of 50%.
No, 2 of 23, 2 of 23. Just 1 minute.
Please.
For the reasons stated in the application, and as we have heard the counsel for the parties, for counsel for the appellant and respondent number 1, comma, the application is disposed of as infructuous. IA 2 of 23 is taken up. The learner counsel for the appellant submits that in the execution filed by the respondent number 1, comma, attachment and summons on the attachment has been issued by the executing court. In respect of certain movable properties, full stop, movable properties. At this stage, and a counsel for the respondent number 1 seeks and is allowed 10 days time to take instructions, and file objections to the application being 2 of 23. Full stop. Noting the said submission, comma, the reply shall be filed within the same time period. Full stop. Within 10 days, yes, within 10 days. Full stop. It is made clear that if the attachment issued by the executing court has not been implemented, comma, the same, or has not been executed, comma, the same shall not be executed till the next date of hearing.
please, your lords.
Subject to conditions to deposit at least 50% amount to the court, my lord.
So we look into it, not an issue, ma'am. This is only a bank only.
That's why, my lord.
That money is secured, rest be assured. Just come June.
Kindly fix the date, my lord, please.
We are fixing a date.
18/6. So number 18, Shimonesh Kumar.
In this case. Let's, these batch petitions, please, my lords. Let's have certain office objections and then, my lords, I will really request, my lords, that these color photographs, I am the respondent, please, my lords, before the learned single judge. Whatever was available to me, please, my lords, in my petition, my lords, I have placed it in the appeal. And my lord, there is a short delay, please, my lords, in these petitions. If my lords could, my lords, the office objection, my lords, can be overruled and the delay can be condoned, my lords. Immediately after vacation, matters can be heard. What transpires, my lords, in these appeals are something like this. Under section 248, please, my lords, of the BBMP Act, Lord, we have the power to exercise, please, my lords, issue notices, my lords, under 1, 2, and 3, to, please, my lords, buildings which are built in violation, please, my lords, of the sanction plan. Here we have done as such. My lords, at that stage, please, my lords, the respondents have approached the learned single judge. But our notices, please, my lords, were quashed on the premise, please, my lords, that 248, my lords, the regulations.
What happened to that writ petition, the earlier one on which reliance was placed?
Which writ petition, my lords?
Yeah, if you see the impugned order,
Yes, please, my lords.
9934. The single judge only follows the dicta of that judgment.
No. That, all those are in this very batch itself.
It's in this batch
Yes,
only.
yes. All of them are challenged in this batch.
Which is that 9934 appeal?
The very first appeal, please, my lords.
This is the one, 1301.
Yes, I presume that I will clarify, my lords.
Now, what do you want? Which are the objections?
My lords, my only.
Quite a few.
The objections are, my lords, that I have not produced, please, my lords, the original pictures. But what I had, please, my lords, which was presented to me, please, my lords, in the writ petition, I have placed it because I will not be having access.
Who had filed it?
The respondents had filed the writ petition, my lords. I seek my lord's indulgence, my lords, to the particular page number of the writ petition, writ papers.
See, we want to have a clarity on 9934.
9934.
First one is not 9934.
Yes. I will produce that, please.
Second one is 9934.
Yes, my lords.
1176.
117. My lords, the office of.
That's the only office objection.
And my lords, page number 86, please, my lords, in writ appeal number 1301. Those photographs, please, my lords, are not the colored version. Because what I had, my lords, I have produced it. I am a respondent. I have received this.
There is an objection on wakalat also.
My lordship, by oversight, my lordship, I filed wakalat in item number 18, my lordship, in seat item number 12. So fresh, that wakalat may be.
You filed the fresh wakalat.
Filed, my lordship, in 18.2, my lordship.
You have filed it?
Yes, my lordship, in 1293/23, appeal number.
My lord, I appear to be intervener in this. We file an intervention application. That will be taken up.
Where is the application? What is the number?
We filed it in 1176.
No, has it been numbered?
File number 1 of 2020.
Yeah, 1 of 25. Who are you?
My lord, we had also previously filed a writ petition wherein an order.
For a similar cause?
A similar order has been passed.
Then why don't you file a fresh appeal?
My lord, we are not challenging the order, my lord. We want to assist the court along with the appellants in this matter.
No, but your point is also same on delegation.
Please. But we are not challenging the order, my lord. We want to assist this court because this appeal.
We will see it. Okay. Objection.
That's all. 86.
The objection on photographs.
That's page number 86. That's what transpires is something like this. I was the respondent.
No, we got it. They must have filed it.
They have filed it.
You don't have in possession.
I don't have it because what was given to me, my lords, I have produced it. Originals I don't have because it was the petitioners who had produced it. I was the respondent, my lords.
Let's see 86. Page 86.
I'm assisted, my lord.
Yes, Mr. Zilga.
I just make this one submission. Now, it really, as Mr. Monish may have submitted, it's only a small legal issue. So all of the other photographs and everything else would absolutely be irrelevant because it's only under section 74D whether that subdelegation is permitted in the absence of rule.
No, we just want to know where is that objection notified by the registry?
That is notified in all the petitions.
Shows that. Shows
in the cause list, it is there.
This is the objection. Is different, not on filing the photographs, but on a description of those annexures. So you appear for all the respondents?
No, my lordship, my respondent in 18/2, my lordship.
In writ appeal number 1293 of 2023, that he has filed a fresh wakalat, and as such, the objection of the registry on the wakalat be overruled. The registry shall give its report on the next date of hearing.
May I make one request? Any office objection regarding these photographs may be
Office objections, if any, on the.
Because originally the writ petitioners,
You know what? It depends upon the clarification which you will give to the registry.
Yes, sir. No, I'm not exactly sure what the objection is, but originally when the writ petitions were filed,
Yes,
there would have been an issue regarding whether it's illegal or not. But that issue was never gone into by the learned single judge. So now we're only on the legal interpretation of 74D.
Just say this. No, you can say this. Objections, if any, on the non-filing of the colored photographs.
Yes,
color photographs is overruled.
Great.
That's all. If any, is overruled.
Because there is a short
But you will still clarify whatever they have asked for.
Yes, sir. And as regards delay, my lords, I think there's a short delay in some of these appeals.
What happened? Give me the files, man. Give me all the files. Huh? Give me the second. Give me the second file. Give me all the files. This is not working.
In first case, 6 days. Second case, there is no delay.
Six days delay. Another delay. One.
Yes. What do you say on delay?
Maybe allowed, my lords.
You appear only in one now.
Oh, yes, my lords. Yeah, 18/2.
We will look into it on the next day, Mr. Oliver. What do you say on that? We don't know. They would be supporting there. No, no, you are
copy
supporting
served.
the appellant.
No copy served.
Tell us one thing, what is the locus? We thought you filed a petition. We have understood you this. You also filed a petition like them. Okay. Who are you? You were the complainant. You were the complainant. So how are you concerned? Tell us one thing. This is a pure question. They are the operating the rules. We say nothing, ma'am. We will just keep it pending. Let's see that. If any assistance is required, intervention possibly only to assist. We will not say anything. Okay? Re-notify, just say it. Just say this item 18.2.
Yes, ma'am.
18. You are in 18?
18.2, my lord.
18.2.
1293/20.
The learner counsel for the this is an application seeking condonation of 6 days delay in filing the appeal. Learner counsel for the respondent states that he has no objection if the delay of 6 days is condoned in filing the appeal. In view of the submission made for the reasons stated in the affidavit in support of the application, the delay of 6 days in filing the appeal is condoned, disposed of.
But
Next.
Any date in June?
What is convenient, give it.
9/7.
Next.
Can I request for 2:30 that time, lots, all petitions could be taken up. On 9/7, can it be requested at 2:30, lots, all appeals can be listed and taken up for hearing?
Get your, I think Mr. Oligo, just get your note of submissions also.
We'll do
It
that.
is a small
Synopsis we will
issue.
find.
But the position has not changed even thereafter. Rules have not been made.
Not yet.
That's
Not
up to
yet.
the government. Now
That
the
is up to-
government has to.
Oh, but you have sent it to the government.
I'm not
Under
sure.
the
I
act,
don't-
See,
government will have to
who would initiate it?
I think the government itself, but I'll just find out.
Who is the rule-making authority?
The government, definitely.
Government.
Definitely.
Or initiation will be at your end.
No, no,
They will
no,
approve
But
it.
I think generally it originates in the urban development department itself, and then it's placed.
Okay.
Great.
Next, ma'am.
Serial number 19.
Serial number 19, this petition has been rendered infructuous.
Infructuous?
Yes, my lord.
You want to withdraw this?
Yes, my lord. I filed a memo.
This is a memo. The memo for withdrawal has been filed by the counsel for the petitioner. Full stop. The same reads as under. The learner counsel reiterates the prayer for withdrawing the petition. Petition is dismissed as withdrawn. Oh, don't say that. Only say memo has been filed. Don't reproduce.
Much obliged.
Number 20.
I appear for appellant, my lord.
Yes, ma'am.
My lord, necessary application will be filed for substitute service, my lord.
But who appears in 21? 21 R1 has been served.
21 state is also party.
Yes, someone is appearing. But only served.
My lord, notice has been issued, my lord. In last date of hearing, I have issued notice, my lord.
Just say this, which is the IM. You have to file an application.
Please, my lord.
Okay, at the request of counsel for the appellant to file an application for serving respondent number 1 through publication. It's only in item 20 this order. Re-notify on. Re-notify.
Grateful.
Both can be tagged together or separate?
My lord, these, no, my lord, separate, my lord.
Huh?
Separate, my lord.
Separate. Okay. Re-notify.
17,
Ending 21, re-notify.
21, serial number 21.
I appear for appellant, my lord.
Yes.
My lord, appellant has challenged order dated 31/5/2023, my lord, passed by Honorable District Court, my lord, wherein the Honorable District Court has passed an order set asiding the said arbitral award and remanded back the matter for reconsideration, my lord. And as such, there is no order for enhancement of compensation passed by the Honorable District Court, my lord. By oversight, it could not be brought to the notice of this Honorable Court, my lord.
So what do you want?
My lord, on 1/7/2024, this Honorable Court has passed an order to deposit 50% of amount through enhancement of compensation, my lord. Kindly requires to be modified, my lord.
So now, how is this appeal maintainable?
My lord?
How is the appeal now? What survives in the appeal? How are you agreed by the order? The matter has been remanded back.
Please, my lord.
So how are you aggrieved?
Kindly pass over the matter, my lord. I'll take an instruction from my senior, my lord.
See, how are you aggrieved? The matter has just gone back to the arbitrator.
Please.
Pass over.
Great.
And that order will be only in item 20, huh? That publication. This pass over.
This is a state appeal, my lord. There are certain office objections. With regard to the office objections, my lord, they have asked for the colored photograph of annexure L6. My lord, my submission is whatever the petitioners had filed, that is the black and white, that is the same that we have filed. So
Yeah.
that may be overruled.
The file. Now, who appears? It's only one. There is appearance only for respondent number 1. What about the others?
I am the
Caveator,
caveator,
my
my
lord.
lords. I appear
You are
for
the caveator.
Caveator.
R18. I appear, my lords. I undertake to file wakalat on behalf of
So
R18.
the notice has to go to the others also.
Yes, 89 of them. So notice has to be issued. This office objection may be overruled, my lord, and there is a delay of 321 days.
That we will look into it, ma'am. Not now. Just say this, the learner counsel for the appellant has would submit that the registry has put an objection in respect of annexure L6
In WP
in
61,
WP 6131 of 2017, which according to her were the color photographs filed by the petitioner in the writ petition. She submits that the photographs being in black and white have been filed along with the appeal for the reason that the color photographs are not in her possession. So the objection of the registry is overruled as of now. Full stop. We find there is an appearance on behalf of respondent number 1.
18, my lords.
You are for 18?
Please, my lords. Lords, I was for the petitioners in the entire.
No, who is Gautam AR?
I, my lords. I appear.
You appear for R1 also?
No, my lords. The caveat was filed on behalf of R18, my lords. I think there is a.
Oh, there's an error here.
Please, my
Yes.
lords, please. 6185 WP is.
6801.
Yes.
States that he appears for respondent number 18, the caveator, and not for respondent number 1 as depicted in the cause list. Full stop. If that be so, see this order. Issue notice. issue notice to the respondents returnable on. So and so accept notice for respondent number 18.
Please.
Caveat returnable on.
17/7,
Much obliged.
23. Ashangadi.
Pay for appellant, my lord. Kindly dispense the notice for respondent number 3, my lord. Is in formal party, my lord.
You want to dispense with?
Please, my lord.
Note in view of submission made by the learner counsel for the appellant to dispense. You know,
Well, I appear for the respondents in item number 24 minutes. Our compilation is ready, Manoj.
Malaz, if I may be permitted to file the compilation.
what is this?
This is the compilation laws.
For what?
Case laws which will be relayed.
Just take it, ma'am. Yes, what do you say?
We also filed a written submission.
Then you file it in the registry. Okay.
Seniors appearing.
I'm appearing for the respondents, Manoj.
Okay, list this appeal for hearing on
14/7.
Manoj, you may just mention, Manoj, my learned friend can also seek instruction because even if they succeed in this matter, the maximum liability is about 22 to 23 lakhs. So in terms of the national litigation policy, their appeal itself will not survive, Manoj. My learned friend can take instructions also on that.
You have heard that?
Yes.
What is the otherwise? What are the circulars?
Manoj, the issue, Manoj, is on the question of non-mention of the advance authorization in the shipping bills of the exported goods. I have imported goods and claimed exemption from payment of customs duties. So if my mistake of not mentioning the advance authorization of the shipping bills is allowed, the maximum liability they can recover, Malats, in terms of the bills of entries filed by me for the imported goods will be around 22 lakhs. So in terms of the national litigation policy, any litigation less than 2 crores before this honorable court would not be
okay.
Permitted. That's the reason.
Take instructions.
Because the learned single judge has granted, because the policy relaxation committee has granted, allowed the error and allowed the export obligation also has been discharged, considering the fact that the goods which have been imported have been used for the exported goods. So there
yes,
are finding with the authorities. Obliged.
Okay.
Obliged.
Thank you.
25, Shri K. Sridhar.
Appearing for the appellant, my lord. My lord, I have to delete R6. I will do it, carry out. This matter may be taken up for admission, my lord. There is a 10 days delay. It's a my affidavit. They have not filed any objection. On merits of the case, my lord, I am filing synopsis, which may kindly be taken note of. Synopsis I am filing. Government clearance. Government. I may be permitted to file a synopsis.
Not single judge has dismissed the writ petition.
You appear for, yeah, tell us what is the,
My lord,
what is your grievance now? What is the ground for challenge?
that the synopsis I am filing.
Give it, give it.
It's a very short synopsis, which may kindly be looked. The entire matter is spelled out in this.
Now, what do you say?
Ah.
How is the order erroneous?
My lord, the learned single judge says that we don't have any locus standi to challenge the order promoting the fifth respondent, who is not a government employee, who is an employee of autonomous institution. He should not have posted this post. Kindly see the synopsis, my lord, for a minute. My lord, the petitioner is a government employee appointed as staff nurse in the Health and Family Welfare Department. After serving more than 22 years in the department, she got first promotion as senior nursing officer. Now she is working nursing superintendent grade 1. Sometimes she was also deputed being senior in the cadre as assistant director. She is quite eligible for appointment of Registrar Karnataka State Nursing Council as per C&R rules for that post as referred in Annexure C, page number 55. 2000.
What are the rules? What are the rules for
Annexure
this?
C. Annexure C. Page number 55. At page number 57, my lord. Nurse Registrar. 1. By selection committee consisting of president, 2 members of the council and 2 other members who are nominated by president. President shall be the chairman of the judgment. Qualification: the registered nurse MSc in nursing shall have 10 years of professional experience, of which 5 years experience in nursing education. This the fifth respondent doesn't have. This aspect has not been looked into by the learned single judge.
No, but
He does not fulfill this condition.
the 10 years.
10 years of experience, of which 5 years nursing education, he doesn't possess. That I stated in synopsis, which may kindly be
No, where are the grounds in the writ petition?
Yes.
They have only
Grounds,
challenged the.
Where is this ground you have taken?
Yes, my lord.
Or at least show us from the impugned order that this was the ground, because what is being sought to allege is locus.
Locus. My lord, as far as that locus is concerned, my lord, the learned single judge has not given any reason to support that finding, my lord, except saying we have no locus standi.
But tell us one thing. Is a person candidate working in an autonomous body precluded from applying?
As per an Annexure C, recruitment rules, he doesn't have qualification, that's one aspect, and he is not empowered to work in the government.
How do we get that?
It's understood, my lord.
Oh, no, don't. Not understood. They should be expressed or by implication.
All right, my lord, even if he is as.
That's a better argument. 10 years he didn't have.
He didn't have.
Okay.
That, my lord, your last may kindly see synopsis.
You apply for the post.
Yes, my lord. What happened, I will say a few facts which I will narrate. In the synopsis, your last may kindly see.
1 minute.
By reading of the synopsis, my case will be.
Now, what was your designation?
Now, I'm a nursing superintendent grade 1, my lord, in the department.
Okay.
My lord, kindly, I request your lordship, kindly look into synopsis. There
Yes.
are 2 pages that will clarify even their aspect also, their contention also. My lord, next point, 2000, fifth respondent was not a
What, has he been appointed? Respondent number 5.
No, my lord, I say I'm an employee in government. He's in autonomous.
So that we got it.
Yes.
Is anyone appointed? Has anyone been appointed as a nursing registrar?
Yes, my lord, he has been appointed as nursing registrar, which was questionable court at a cost of 50,000 imposed on him. Again, he tried. He never worked in the teaching side throughout his career.
In which matter it was set aside?
That is page number, my lord, page number, annexure K, page number 95. In respect of fifth respondent only, the writ petition decided. Annexure K, page number 95. This is in writ petition number so and so, my lord. The short order, my lord. Pursuant to order dated 23/7/19, first respondent state repatriated the petitioner as well as the contesting respondent number 3, Srimati B. Jyoti, wide notification dated so and so. In view of these developments, present petition does not survive for consideration. The first respondent shall strictly adhere to the method of recruitment to the post and appoint such of those eligible persons. There should not be any deviation from the rules of recruitment governing the post. With the above observation, petition stands disposed.
How do we get from this order?
This order,
the gentleman who was sought to be appointed is the same person who is respondent number 5.
His name is K. Mallo in annexure K. Fifth respondent is also Mallo, fifth respondent, present case. And the department is hereby directed to pay 50,000 cost for having violated regulation governing the post of Registrar Administration Karnataka State Nursing Parishad from time to time by issuing order of appointment at a given point of time, 5/7/2019, which was subject matter in WP number so and so, and pending consideration, petitioner and contesting respondent number 3 was given posting on 18/7/19. While cancelling 5/7/19 notification, both the notification are contrary to statutory rules. Perusal of the file, it is evident that the officers of the department have appraised the rule portion, but the concerned minister stated to have insisted for issuance of order in favor of party. Therefore, cost shall be remitted to the Legal Service Authority, High Court of Karnataka, so on, so on, so. Well, what happens, using his influence, he wants to come on administrative side, holding the.
Who appears for the respondent number 5?
5. Then what happened, my lord? Then, my lord, then in the writ petition, the learned judge observed, all right, you make a direct recruitment by amending the C&R rules for this post. They gave up that also.
Is he occupying the position?
Yes, my lord, even now he is occupying this position.
Who appeared, ma'am? What is your case? State's case.
State, my lord, your lordships may kindly see para number 6, my lord, of the order of learned single judge.
Yes.
My lord, where we have stated that, my lord, the learned counsel appearing for nursing counsel as well as learned AGA submit that the process of recruiting a regular nurse registrar has been held up since there is a proposal to amend C&R rules and government is seriously considering the same. And the process of amending the same is yet to be final stage. It is submitted that as soon as C&R rules are framed, a regular nurse registrar would be appointed in accordance with C&R rules. My lord, they have questioned only the in-charge arrangement made to one Malu, my lord. As such, my lord, the learned single judge has come to conclusion that they have no locus. Secondly, my lord, in so far as state is concerned, my lord, we have stated that, my lord, C&R rules are yet to be framed.
How long it would take?
My lord, that I will take instruction whether what is.
Obviously,
No, my lord,
you give the benefit to a person.
Please, my lord, that I will.
My lord, for that aspect of the matter, I filed a contempt, wherein they have filed affidavit saying that we have given up amending the C&R rules.
Oh, they have given up.
They given up. Now they want to continue this man indefinitely.
Just take instruction.
Please, my lord, please.
To enable the Council for the State of Karnataka to take instructions on the status of formulating C&R rules. C&R rules for the post of nursing registrar in the nursing council.
Please.
Re-notify on. Delay of 10 days
10
is
days.
condoned.
My lord, I am permitted to delete R6, which I have deleted. Just I will carry out deletion.
The counsel for the appellant is permitted to delete. The counsel for the appellant request for deletion of respondent number 6 from the array of parties. Stop if that be so, comma. The request as made is granted. Let necessary correction be made in the memo of parties. Before just notify the appeal on. We take on record the synopsis filed by the counsel for the appellant. Next.
7.
Maybe a little in the month of June, my lord, so that 9/7 is to.
Next.
26.
For the appeal for the appellant in this matter, my lord, we have filed our judgments, my lord. Synopsis, my lord, we will file it in the registry. Lords may grant me a week's time, my lord.
For?
Filing of synopsis, my lord. In fact, arguing counsel, my lord, he had to undertake travel today, my lord. I seek for a short accommodation in this
You
matter.
have also filed.
We have not filed also. We'll file your
Counsel for the parties to comply with the order dated 6/2/2025 before the next date of hearing.
17/7.
Obliged. Obliged.
Serial number 27, government advocate.
State appeal, my lord. Last occasion, my lord, lordships had directed, not the respondent counsel to give the objections, whatever the objections are, my lord, with regard to non-filing of the counter which were filed in the writ petition. R3, R5 and R7, my lord.
What are you saying, ma'am? What is submission?
My lord, last occasion, your lordships had directed respondent counsel to give, my lord, the objections are that, my lord, we have not filed the reply which were filed by the respondents. So since it is not available with us, my lord, as such, we are not unable to comply the objections. So directed, last occasion, your lordships had directed respondents to give their reply which was filed in the writ petition, so that, my lord, we can comply the objections.
My lord, R3 and R7, I'll give the copy of the statement of
Yes, ma'am. Tell us.
R3 and R7 has filed the
R3, R5 and R7 have
in
filed.
writ petition. R3 and R7 has
Okay.
filed the statement of objection. I'll serve the copy to.
You're giving?
We will
You have
comply.
given, you have given that.
You given to them
Just
for
say
the
that,
KDB.
Whatever reply they have filed, they have given it now. We will,
Writ appeal R2 and R4. Appealing for R2 and R4.
You appear for whom? R3?
R2 and R4.
And what was your status in the writ petition?
In
For which respondent?
there R3 and R7.
Okay. The counsel appearing for respondent number?
Here R2 and R4.
R2 and R4 has
In writ
given the
appeal.
copy, has given the copy of the objections filed by the said respondents in the writ petition 18313 of 2022 to the counsel for the appellant. Who said, now what will you remove the office objections?
Yes, my lord, we will. 27.1, my lord, we have to serve copy. On R1, my lord, we will do that.
No, but now since now these objections have come.
Please, my lord.
So what follows? You have to remove the office objections?
Yes, my lord.
So the counsel for the appellant states that the office objections put by the registry shall now be cleared. Additionally, she states that a copy of the appeal paper book in WA 405 of 2024 shall be served on the counsel appearing for the respondent number 1.
Please.
So noting the said submission, list these appeals on.
16(7),
Applies to me.
28, 28, Jay number.
For the appellant minutes. My lord, so far as issued notice to R2 and 3, they are not parties in the appeal, my lords. This is a defendant's appeal. Defendant 2 and 3 were the directors of the defendant number 1 company, and the suit has been dismissed as against them. So they've not been made parties in the appeal, my lords. If your lordship would take page 72, my lords, in the impugned order. It is decreed, ordered and decreed that the suit against defendant 2 and 3 is dismissed.
But they were parties before the court below, no?
Yes, my lords, they were parties.
They were parties and they have been made parties here also.
My lords, no, my lords, they've not been made parties. In fact, there's a specific government saying that.
See, who are those respondents?
They were, my lord, I am for the respondent 1. They were the directors of the company.
They were directors of the appellant, my lords.
The appellant hearing.
No, both were their parties before the court below.
They were parties.
They
before the
were,
court.
and here also they have been made. You may not be having possibly the corrected. We have.
Could be, my lords.
As per our appeal memo, both are there.
My lords, I will verify it, but the notice may be dispensed with, my lords, in that case because they're directors of the appellant company.
What was the liability fastened upon?
It was dismissed as against them.
Dismissed.
Please, man.
They were made the formal parties, my lord, and then there are no liabilities personally. There's no personal allegation.
But
they are only responsible to be answerable. That was the
page 72, my lords.
And this adjunctee was the plaintiff. They were respondent. Okay, he has filed. Now we have to. What do you say on deletion?
My lord, I have no personal allegation.
You have not challenged it.
No, I don't have an issue against them. They are the directors and made party only for them to be answerable as a company, because I have to make someone responsible there. I made them the formal party. They had challenged that and they sought for a deletion, which was rejected, my lord. And then they came to they filed a writ petition, which was also, they withdrawn that case. So, my lord, in the appeal, as there's no liability on them, I don't insist on them being any party. They are not answerable in any way. I think there's one director is no more working also there. Only one is there, still there. So there's nothing on against them. Current directors may be answerable, that's all.
So we'll delete them.
I don't have a problem.
Please.
And one may be, in fact, one may be deleted. One should be even the director as of now, my lord.
My lords, but the suit is
He's the current director.
See, no liability fastened upon. You don't know what were the averments, allegations, quad, respondent.
There was nothing.
Then why should they be?
It's not required. And they may serve a copy to me because, my lord, I was not served a copy because they filed a petition there.
The Lena Counsel for the appellants request that the respondent number 2 and 3, who though were parties, the no liability has been fastened upon on them in terms of the impugned judgment decree dated 27/9/2000, dated 19th September 2024. So the learner counsel for the respondent number 1 has no objection if the said respondents are deleted from the memo of parties. Let necessary amendment be carried out in the memo of parties, and even an amended memo of parties be filed within 2 weeks from today. So let a copy of the appeal paper book be just a copy of the appeal be given to the counsel for the appellant respondent. Okay. Shall we admit it? You have deposited the amount?
Please, my lords, we've also filed a memo of compliance dated 12th of March. My lords, the
Where did you deposit?
my lords, there might have been an error on the part of the party. There's a term deposit that is open in the name of the High Court, Registrar High Court.
Not like this.
My lords, we will
come here.
Yes, my lords. If your lordship would kindly pass an order directing the same, I will take it to the party.
How many times we reiterate our orders? You have seen this order of 29/1?
Please, my lords.
What does it say?
My lords, that it has to be deposited here.
That's right. One order is enough. You will not reiterate. If this is your understanding, you have done it.
My lords, there isn't agreed that there is an error in the understanding of
Then
it.
you will correct your error and then deposit it.
My lords, if I may kindly request that the order be complied once more, my lords.
No, we will only say that we will record your submission.
Please.
We will record this submission also, that you will comply with this order for which time be extended.
Please, my lords.
That we will give you.
Please, my lords. If my lords, the compliance memo be taken on record, it may be rejected saying that it has to be complied once more.
What compliance memo?
We filed a memo, my lords, showing the term
We
deposit.
will not accept it.
Please, my lords, the order may be passed just so that I can show the party, my lords, that it has to be deposited in court.
We will not go by this.
Very well.
That is something between you and the client. But we are very clear.
Please, my lords.
Just say this. On 29/1/2025, this court had stayed the operation of the impugned judgment decree dated 18/9/24. Check out here.
19/9.
It's 19/9.
Please, my lords.
19/9/24 in COM OS 78 of 2020, subject to the appellant depositing 75% of the decretal amount with the Registrar General of this court within 6 weeks. First off, we have been informed by the counsel for the appellant that the amount, the deposit as directed to be made with the Registrar General of this court has not been made. Rather, a term deposit has been opened for the amount, for the 75% of the decretal amount. She submits that the amount in terms of order dated 29/1/25 shall be deposited within how much time?
May I request for 4 weeks, my lords?
Within 4 weeks from today, in accordance within 4 weeks from today, for which and as such we accordingly extend the time by 4 weeks. On such deposit, the registry shall take further action as per order dated 29/5/25.
Grateful.
Let's go.
Date
We'll
may
come back after lunch.
Date may be.
Nine
Date
seven.
may.
Date we are giving?
Nine
Right.
seven.
My lords, if I may make a mention. My lord, serial number 46. I appear for the respondent. I've informed the counsel for the appellant as well.
Appearing for the appellant, ma'am.
If I may please be granted any date after the vacation, my lord. Senior counsel has been engaged in the matter. He's unable to appear in
Who
the
appears for the other side?
Appellant for the
Mr. Nair, you appear?
Yes, minutes.
Just say that at the request of
The short
counsel.
accommodation, minutes, we have no objection, but minutes, if it could be heard, if possible, on Saturday.
We'll go beyond vacation, Mr. Nair. It is the request of counsel for the respondent for an adjournment, re-notify on. Yes. We'll come back.
My lord,
Let's wait for.
Ma'am?
8 is again, not 20.
8, my lord, some for the respondent. Need to file each of people that have not received for a third opportunity. For the applicant. Serial number 38. Please, my lords. Respondent, my lords. Maybe listed after vacation, my lords. Grateful, my lords.
17-7.
My lord, serial number 16, my lord, 16. It was passed over, my lord. I am for the appellant. Morning respondent was present. Kindly, it may be taken up after vacation, my lord. Respondent is there. Yes, my lord. Connected matter is there. I am for a 16, my lord. 1658 of 16.1 not represented in morning also, my lord. No, my lord, only 16. R3.
(17-7).
Public. My lord, list number 2. List number 2, praise stamp to complete the office objection.
Yes. Do you want?
Praise stamp, sir. Time, 1 week time.
In 6 weeks. Who is the counselor? Who is the advocate?
I am the petitioner.
Who is the counsel on record? Who is Babu Dia?
My senior colleague.
Where is he?
The authorization.
Who is the petitioner related to the detainee?
He claims to be the friend of the alleged detainee.
Yes,
16-6.
Achha.
Serial number 29.
If appellant, my lord, I appear for the respondents in this matter.
Yes.
My lords, one of the respondent have filed wakalat for. The other respondent, my lords, he's traveling. So therefore, I seek some accommodation to file wakalat for the other respondent.
Just
notice-
say that so and so appears for respondent number 1 states that he shall file wakalat on behalf of respondent number 2 as well.
Yes, my lords.
Respondent number 2 as well. So noting the said submission, directing the wakalat be filed within 1 week, re-notify the appeal on.
My lords, I'm told he's coming back only on 7th of May.
On or before 6th of June.
Grateful. Please. My lords, one more submission I have with my lord's permission. We have also preferred a writ against the same order. I mean, sorry, commercial appeal. And that is before another bench. My lords, that's listed on 24th. My lords, it may be, there's an execution that they have.
When is the date there?
It is on 24th, my lords.
This coming 24th?
The next week, my lords. There's an execution. That is why there was some urgency in moving.
No,
that.
we will place it along with that appeal.
Please. Grateful, my lords.
Okay. Just say that, just cut that. Cut the order. We have been informed that We have been informed by the, you are aware of this?
No, my lord, I'm not aware, my lord. Only today they
The
are informing
counsel
us.
for the respondent
Notice was
number
not
one
issued.
states that even the respondents or respondent number one has. filed.
Respondents, both.
Both
Both have-
respondents have also challenged the impugned judgment dated
27 September 2024. my lord.
just show us the file, it's not opening. Judgment dated
Page 18, my lord, next area.
27 September 24 in COM OS number 896 of 23. And the same is listed before another bench. Stop. If that be so, subject to the orders of the Honorable the Chief Justice, comma, what is the appeal number?
Appeal number 191 of 2025.
Being appeal number, being COM app number 191 of 2025.
25.
If that be so, comma, this appeal, if that be so, comma, this appeal shall be listed along with the said appeal, subject to the orders of the Honorable the Chief Justice.
Please, my lord.
Great.
Grateful, grateful.
Before appropriate bench, subject to the orders of the Honorable
Honorable
the
Chief
Chief
Justice.
Justice.
Please,
Great.
grateful.
Till number 30, government took it.
I'm for respondent, my lord. My lord, senior is inconvenienced, my lord. Senior is inconvenienced, my lord. After vacation and date me.
At the request of counsel for the respondents.
One, my lord. One, my lord.
Respondent number one. These are all batch matters. We have heard this matter, I suppose.
Yes.
We have heard it.
Heard.
Yes.
Last occasion I heard one. Now I am for 30.3 and 4 minutes. One is the state.
State is what?
State 2 is the.
31, 32, 33.
Is it a part of it?
Sorry, my lord, there's a state appeal in this.
Huh?
This is with regard to Anganwadi worker. And
This is
the
a parted matter, no?
Pardon me, my lord.
Yeah.
We have filed an affidavit also.
Yes, we have seen that. He's seeking an adjournment.
After vacation, ma'am. Senior is inconvenienced.
My
They
lord,
say adjournment is sought by the counsel for the respondent number one.
my lord, we have asked for a stay, my lord.
Why? The contempt is here only. What is the difficulty? Contempt is along with these appeals.
Stay of the order because,
Doesn't make any difference, ma'am. Tell us one thing. Contempt is along with this batch. We will hear it together.
Yes, ma'am.
Are they precipitating the contempt? They can't. It's
They
part
can't.
of this batch only.
right.
A list on these petitions shall not be treated as parted. Okay.
Please.
In which number appeal?
30, 31, 32, and 33.
At the request of counsel appearing for respondent number?
30, 30.1.
No, in all your.
Also respondent.
in
30.1 petitioner. Content.
It is a matter of promotion wherein they are seeking to be promoted, which cannot be sought as a matter of right.
That's right. We
Yes,
have
ma'am.
heard it. But let it be. He is seeking an adjournment. We'll have it at the request of counsel for the respondent. No?
Yes, ma'am.
Kalavati.
Yes, madam.
Respondent Kalavati. Adjourned to.
10/7.
Much.
An earlier date, my lord, at least. An earlier date.
Just see it. It may not really be convenient in June, ma'am. Just have. Next.
30.
Part heard, my lord.
No, we have released it. We said will not be treated as a parter. Let's see. Okay, thank you. Next.
31.
Much obliged.
31.
Appearing for my appellant, my lord.
Senior is not available. Can kindly adjourn this matter.
Serial number 31.
Appear for the
Appearing for the
respondent. Respondent 5 and 6, my lord.
Just say that at the request of counsel, you are for the appellant.
Yes, my lord.
Request counsel for the appellant adjourn to.
16-7. 32. Shri Chelvaraj. Serial number 32.
Matter is pertaining to that interstate seniority in the railways, my lord. This honorable court had directed the respondent to file an affidavit whether the same in the same manner if they are following it in Mysore and Hubli. So
What is the affidavit? Have they filed it?
they have not filed it, but in the morning he had told me that today they will file. So I don't know. Mr. Bhushan had told me.
Just say this. Just say that the additional affidavit as was directed in the order dated 4/3/25 shall be filed on or before 5th of June 2025. Shall be filed by the respondents on or before June date. Okay.
Please, no, date may be fixed. Please.
17-6.
Much okay.
Next.
Serial number 33.
I appear for the respondent in this matter, Your Lordship. Your Lordship, one humble request in this matter, Your Lordship. By this court, there was another matter directed for me today to appear before the registered judiciary for the inspection of documents, and that matter has been set up at 3 o'clock, and this matter requires consideration in length.
$702. Very interesting to see this 33.
But I guess rejection of the counterclaim filed by me.
There is a counterclaim before in 34. Should independently challenge a 34 petition. Maybe nomenclature as a suit.
Please, madam.
It's not suit in that stricter sense. It's 34 petition.
Please, madam.
There is a question of counterclaim. You will ask, maybe for enhancement or something.
That was my contention there below, Your Lordship. That's what my contention was that they have to challenge it through a press suit.
Madam, I'll make my submission, madam.
I hope we are clear. Against award.
I understand, madam. I ought to have challenged then a separate arbitration suit instead of filing and counter.
Look into it. You don't know what remedy you will have now.
That's what. Madam, here even the guided value has not been taken into consideration, madam. Even though the first time, madam, the.
How much would be paid for a counterclaim on the claim you have made? That's what you have paid.
Please.
Don't know on a 34 petition how much is the court fee. It will not be appeal to at least a suit. Possible.
I'll find out.
They say at the request of counsel for the
9-7.
Much obliged.
So if the counterclaim is rejected,
Please.
then this appeal is under what section? Which section?
37.
How can that be beaten?
I'll do my homework.
34.
For the appellants, my lord, I have made this application for an early hearing. The short point involved is, my lord, whether the award which was granted in my favor, whether the arbitrator was justified in granting the award within a period of 18 months, having regard to 29(3). My lord, the pleadings were completed on 31/1/2018. My lord, the matter was 31/1/2018. The matter was reserved for judgment on 31/1/2019. The award was passed on 24/6/2019, well within the 18 months period, against which they filed the 34 appeal. That has been allowed, against which I have come before my lords. On the last date, my lord sees the order sheets dated 19/11/2021 and 2/9/2021. My learned friend was called upon to prima facie. This court was of opinion that the appeal could not have been allowed, and he was advised. That's why I said can be disposed of on that short point, my lord. I have a synopsis also ready and a couple of judgments also.
In fact, in the IF for early hearing, I submitted the documents also, Your Lordship, because the connected matter suit is pending before the trial court filed by the other persons who adjacent land. Your Lordship. There they obtained injunction, partition suit is pending. So as far as this petition appeal is concerned, I have to give the way for the land of the appellant. So it is impossible at present when the suit is, that is also recorded in Your Lordship in this, by this Honorable Court.
Those are all not necessary for the present matter at issue, my lord. Because in fact, in the connected matter, she has given up her claim in the suit, a compromise, and they have not challenged the award.
Your Lordship, section 29 is very clear, Your Lordship. That is amended, 29A, capital A, Your Lordship. That was amended from 2019, Your Lordship. That amendment has taken.
I have a list of authorities.
Clause 3, Your Lordship, in that the parties may by consent extend the period of specified and subsequent for making the award. So there is no such consent, no applicant. Then 4 will come into play.
It was reserved for judgment well within 12 months. As I gave the dates, my lord, the pleadings were completed on 31st of January 2018. Disposed of also, it was within the period of 6 months, within a period of 18 months. 6 months, yes, my lord.
No, not 6 months, maybe it's 12 months.
12 months is 29A1. Then kindly come to 3, my lord, 29A3.
But there was no consent, no?
My lord, the consent, the judgments are this: if you participate without objection, the consent can be tacit, can be oral, or by written. Because the matter had already been posted for judgment. Therefore, everybody, my lord, it's like this, my lord. If it had been allowed in his favor, he would have kept quiet. So now, just because the award is.
So within 12 months, it was reserved.
It was reserved.
And He filed 34.
He filed 34 thereafter because it went against him.
So 29A was the ground.
Yes. And this court has, in the earlier order, this court has, yes, please.
Was there any proceedings? Or were there any proceedings before completion of 12 months?
Yes.
Was the dispute or the arbitration proceedings reserved for judgment within 12 months?
Yes. Yes.
And when actually the 12 months expired?
The 12 months
before the
about
12 months,
about a fortnight before that.
Fortnight. And the award was rendered?
The award was rendered within the period of the next 6 months.
The next 6 months, but surely no objection till that?
No objection. No objection. No, nobody raised any objection.
And when was the award was challenged within the time period?
Thereafter, yes. I have a set of authorities.
And the only thing is now whether what is the law is apart from that. I have made in my earlier application the impossibilities of the contract.
All that
now,
we
even
see,
if we
that is
succeed,
not,
assuming that
is not for, that is not.
Suit is pending in the adjacent land.
Yes.
Yes, only on the purpose of limitation only code, not on the merits. It has not been discussed. That's why I made even the last occasion earlier. The matter can be remanded back, and let the court have the opportunity of there will be a inquiry, because other issues have been raised in section 34.
Yes.
It is unconnected.
His
obligation only to provide.
Yes.
For a decision on merit.
Yes, Your
May I have one small submission? Insofar as my friend is concerned, my lord, the main issue, he is unconnected. His case is limited to the road extent. The main contesting parties are not before my lords. In fact, they have surrendered all their rights to the respondents 2, 4, 5, and 7 and 8. They have conceded in that suit. They did not challenge the award. Only one Mariamma challenged the award. In the suit, she gives up her claim in favor of the other contesting. Insofar as them, I'll proceed. He is confined only to the road area. I'm not contending both.
Yes.
He succeeded in his 34 in whatever manner.
Yes, sir. That's
you are agreed, you have come. If you are saying that you are not agreed because nothing has been given to him, he is only agreed. He is only concerned with the limited challenge to 34,
yes.
which he succeeded.
That's all.
And I don't think you actually should have filed the appeal. Before having been filed, having been succeeded, whatever it's worth, you have come in appeal. If he has pressed his 34.
You have anything to say? You can say.
How is it even connected on marriage? Subject matter is different. Subject matter of the property is totally different. Subject matter of the property is totally different.
He has pressed his 34 and 29A was non-issue. 29A was a non-issue. He could have gone into merits.
Merit, that's what. Because only that section, provision only Leonard trial judge has taken and decided. So,
my lord, one submission. The list that my learned friend is referring to is totally unconnected to the subject matter property. Right.
The thing, no.
The challenge is only to the extent award set aside.
Please.
In view that the parties have not consented for extending the time for the arbitrator to render the award. That's right.
Correct.
The trial court accepts it and set aside the award. Submission is set aside this, send it back. Let the 34 be decided on merits of the award. Whatever it's worth. If something he got something, he has not got something, that for you to work it out before the trial court. You will argue. Getting?
Absolutely.
If 29A was a non-issue, if he has filed a 34,
please.
then the trial court would have gone to the merits of the
That's
case awarded by the learned arbitrator. In his favor or not? According to you, the others have not come forward to challenge the award.
Correct.
You may have a remedy, you will see. But the fact remains, we don't know. You have to examine in law. The award technically has been set aside. What is the worth of that setting aside of the award for the others also? I hope we are clear. We are clear, I suppose. Technically, the award has gone. What do you say on this? Whatever he has said. You want to look into it, think over it, do well.
No, the limited submission that I want to make to my lords is the only challenge was with regard to the passage of time in passing of the award. So on the merits, they had nothing.
No, your lordship may kindly see, several grounds are taken in the arbitral suit. All these things, only 29A has been taken up and decided, but all other matters.
Possibly what we are saying
That's all.
is,
Please.
your ground of challenge is only 29A.
Not only other provisions,
All the rest
it's
has
very
been held in
clear.
my favor. The rest has been.
Kindly see the grounds, your lordship, which I several grounds
have not
I
been
have.
accepted, my lord. Those grounds were never accepted by the trial judge.
But suppose he has accepted his first ground.
That's
Then
what.
he can't be a worse place in the sense that now he can't agitate the other grounds. If it is set aside, let's say
If it is set aside, it will be set aside on the entire.
Even in fact, your lordship, several issues have been framed by the trial court. Your page number, ink page 13. Several.
Over it. Whatever you say, that this is what has been put by him. Want to consider it, look into it.
What accommodation?
Just say that the counsel for the respondent. Which respondent? You have which respondent?
1 to 4.
Respond 1 to 4 in the first matter.
So you have for all the 1 to 4. Are the others before the trial court?
He's not for us. 1 to 4 in the first matter.
In 2799.
Connected matter.
You are in 2799.
I am in 2778, your lordship, first matter. These are-
2799.
No, first matter.
Keshav K for R1.
Keshav, yes, for them.
1 to 4. States that
No, 2788.
all has been.
Other ones. It's correct, it's correct.
It's for Mariaman.
It's for Bhasha and others.
Been set aside. Only on the ground. Parties have not consented for extending the time for the learned arbitrator to render the award
In fact, your lordship,
beyond 12 months. Or within 12 months. No, beyond 12 months. Or they say, or a further period of 6 months. After the expiry of 12 months. The due order be set aside, can be set aside, and the matter be remanded back to the trial court for consideration of the petition filed by the respondents 1 to 4.
and all the issues, your lordship, all
On
the.
section 34, under section 34 of the Arbitration Reconciliation Act, on merits of the
Yes.
on merits of the challenge to the award. Okay. The learned counsel for the appellants seeks some time to take instructions. And they request me to give it up. Appellant, say appellant.
25-6.
This would hold good for the other one also. We find there is no appearance in MFA 2799 of 2020. But you appear for the appellant.
I am for the appellant.
For the respondents. We find there is no appearance for the respondent in the connected appeal.
I have filed a memo that first respondent Mariama is no more.
It abates.
No, it doesn't abate.
Respondent number 1 in that appeal
Is no more.
We also know who has been filed.
No, I have memo has been filed, my lord, on.
It's not listed, I suppose.
Yeah, it's not listed, but I've already filed the memo on record, my lord. On 18/4/2022, my lord.
It's not listed here. No appearance for the respondent number 1 in this appeal. As time is sought by the counsel for the appellants in both the appeals.
5/6.
25/6.
Still number 35.
Lord, I appear for appellant in this matter. This is a matter where the appellant has challenged the seniority for the post of assistant professor, my lord, and now the post of the assistant professor is vacant. I have moved an application for early hearing. My lords may consider my application and fix a date for final hearing of the matter, my lord.
Not for assistant professor, for the post of professor. The seniority has to be fixed in the cadre of assistant professors, which has been allowed. The writ petition is came to be allowed. The short point which considered by the single judge is there is no notification for appointment. On our request, we made our applications, both the appellant hearing and the petitioner.
Who is the post? Is it professor post?
No, the initial appointment is for the assistant professor.
No,
This professor post is by virtue of promotion. In view of the fact that the seniority list has to be restored in favor of the contesting respondent hearing. The only issue is whether the date of entry or if there is no notification as required under the case's general recruitment rules, it is only the age which will prevail. The learned single judge considered though there is no notification for appointment, it is only on our request we have been appointed, and the appellant hearing, both. There is no selection committee, nothing. Because it is a new medical college which has constituted in 2007. The state government has taken a decision, policy decision, that there should be a medical college for each and every district. At that moment, there is a dearth of teaching staffs. So they have to accommodate the teaching staff before the MCA or NMC conducts the inspection. In considering that, we made our request and we have been appointed. There is no notification, nothing. Not on the same date, on a different date, but though we have made our request, there is no selection process as conducted. But nevertheless, the appellant hearing is reported only after 1.5 months. Considering the fact that there is no selection process. There is no criteria for selection at all. It has been taken place. It is not. The process now is even otherwise it is a walk-in interview. But the fact remains in this particular instance, not even a walk-in interview. It is we have made our initiation, not by the institute. Now we are both are assistant professors. Associate professors. Now we are the. At the moment, I am holding the seniority. Otherwise, there was two issues. The promotion to the effect of assistant professor to in the assistant professor, I am hold the seniority. But what the promotion committee considered it, as per the C&R rules, it is seniority come merit. Nevertheless, the DPC conducted holding that it is a selection post. I have challenged that also. Yes, both I have challenged. I have challenged that only. Realizing that I am challenging the promotion after 3 years, the appellant came and they filed this challenge the seniority list. In the wake of the fact that I am challenging her promotion. Your Lordship can fix up the date since Your Lordship. Because it's your lordship order which says that there should not be any promotion till we hear. All are represented, all are represented. Your lordship, it is not admitted. It is not. Sorry, your lordship. No, your lordship has given the date later on. A roster has been changed. It has come before. There afterwards, it's not listed.
It is not admitted.
It is not even admitted as of now.
Fourteen-seven.
Public.
Serial number 36.
My lord, I appear on behalf of the appellant, my lords. My lords, I request for a passover, my lords.
My lord, I appear for the respondent, my lord. My lord, just 2 days back I entered appearance, my lord. There is an application filed seeking for condonation of delay of 776 days, my lord.
My lords, I'm sorry, the court is not audible, my lords. I'm unable to hear the court.
Yeah. Ma'am, we will just adjourn it.
Please.
Okay? Not possible.
Any short date, my lords?
We'll give you a date. Though a passover is sought by the counsel for the appellant. You appear for appellant?
Please, my lords.
No, it's not possible to pass over the matter. Re-notify her.
27.
Please.
My lords, I'm only request, my lords, any date in June.
Not possible, ma'am.
Great,
Serial
my
number
lords.
37. Shivmekula.
Appear for the appellant, ma'am. For the respondent, kindly pass over, my lords. Senior is held up in CH-17. He'll be on his way.
We'll have it some other day.
Lords, it's already like.
It's not possible.
Kindly pass over, my lords.
Pass over.
Pass.
38 adjourned. 39. Shinja Alva.
Respondent. 39. None for the appellant, adjourned to.
17-7.
Short date, Mikhail.
40 adjourned. 41. P.N. Rajeshwar.
I'm for the respondent.
Today, inconvenience, my lord. Short for 10 minutes. Price for only 10 minutes.
At the request of counsel for the appellant, adjourned to.
17-7. 42 adjourned. 43.
I pray for the applicant, Your Honor. I pray for time. I pray for time. My senior is not keeping it.
At the request of counsel for the appellant.
Eighteen 7. 44.
My lords, the senior counsel engaged in a matter is held up before the arbitration center, my lords. A date may be fixed, my lords. We'll file our sins as well as the compilation of judgments in this matter.
At the request of counsel for the appellant.
18-7.
Great.
45.
Ready for the appellant, Your Lordships. Likewise, I seek a short accommodation in the matter. The interim order may kindly be extended.
Morning, they said that the counsel is not well. I said, okay. Last occasion, my lord said it can, all objections what they have raised can be raised before the arbitrator. It appears counsel is not well, all right. Some other date.
At the request of counsel for the appellant, adjourned to.
Short June alone, date court.
Just, you have heard him. Is it under section 9?
Section 9, Your Lordship.
And you will go work it out before arbitrator is in place.
Not in place. The CMP is still pending before the High Court.
Is it pending?
It's pending.
Is it pending?
It's pending, Your Lordship. It's pending.
Then that I think that gets over also the same thing, same matter.
Pardon?
Same situation will arise.
But the only thing is pending appointment, they may insist upon. Give a date.
The interim order may kindly be extended.
Interim order, or there is interim order if any to continue.
27.
CMPR.
Next.
46 Arjun, 47 Shajit Bibi. 47.
47, yes.
In this, both plaintiff and defendant, both, this is Murad. One appeal is by the defendant, another is, both of them are not happy with the award passed by the learned arbitrator. Murad, in this, I am appealing for the defendant, this is defendant's appeal. But the learned arbitrator, this is basically in respect of the joint development project. In 2013, they have entered into MOU. Thereafter, Murad, under the MOU, a sum of rupees 60 lakhs rupees was agreed to be paid. Out of that, 50 lakhs was paid. And Murad, they were supposed to get to a conveyance deed, and thereafter they are going for a registered joint development agreement. And Murad, they obtained the registered joint development, conveyance deed. Thereafter, they have entered into joint development agreement. In the joint development agreement, there are several clauses. One clause is very clear. It is an irrevocable joint development agreement. By virtue of under the joint development agreement itself, they have provided for a irrevocable power of attorney also. They have entered into joint development, and thereafter, after obtaining this, there was he has not obtained kata, property was not converted. At our cost, we got the land converted, and kata also we obtained. Thereafter, we applied to the BDA for sanctioning of the plan. When we submitted the plan, the BDA sent the letter endorsement to stating that there is on the eastern side there is a nala. That is nala means Rajkaluve. So you have to leave 75 meters from the nala, and you file a separate plan for sanction. Then we requested them to give their consent, because under the agreement we are supposed to give larger extent. In view of this NGT order, the extent will be reduced. We asked them to give consent. They have not given consent. Then they have also brought to their notice that the matter is before the Honorable Supreme Court. If the Honorable Supreme Court set aside the order of the NGT, then we will go for the same thing. Otherwise, it will be reduced. They have not agreed. Instead of that, they issued a letter, notice cancelling the agreement. Then we said, no, you cannot cancel it because the agreement is very clear. It cannot be cancelled. One. Secondly, we are ready to give the super built up area, reducing to the proportionate to your right. For that, they have not agreed. Then ultimately they invoked the arbitration clause. The arbitrator, learned arbitrator, was appointed. They filed a claim petition. We filed the counter claim. On the claim petition, their main the contention is cancellation. The lordship go through the agreement, joint development agreement. The first clause itself, I'll read just. In the clause number 1 itself, I'll read it. The joint development, that in pursuance of the.
Who is for the respondents?
Venkat Reddy.
Oh, not here. I'm sorry. I thought he was. I met him outside. I thought he's here. But both of are not satisfied. Therefore, your lordship may kindly. Lordship may kindly consider for admission and call for the records are already there. Both the parties may be filed the paperwork, and your lordship can dispose it
Just
of.
say this, none for the respondents in COM 13724. Let the trial court record be requisitioned before the next order. It's prepared, it's there. Just cut it, counsel for the parties to file their written submissions along with the judgment they want to rely upon. Judgments. Just give it in July, ma'am.
The interim order may kindly be extended.
Interim order, if any, in which matter?
In 137,
Interim order, if any,
14-7.
to continue till the next date of hearing.
please.
48. Shri Aditya.
For respondent in this matter. I appear for respondent. I appear for respondent, my lord. It's appellant's petition, my lord. Appellant's claim before the commercial.
None for the appellant, adjourn to. You're for the appellant? No.
17-7.
Great.
49. 49.
I'm for the appellant, my lords. I pray for short accommodation, my lords.
My lord, in fact, on other day, the learned senior counsel submitted that he will get back with the amount to be deposited, quantum of the amount. Now they are seeking, once again seeking the adjournment.
Just re-notify, give it in 25th, 26th.
Much
Get
obliged.
your instructions, ma'am.
Much obliged.
25.
25th.
Right. 50. Serial number 50.
I appear for the appellant, my lords. This is a commercial appeal arising out of AA order 50 of 2024. My lords, there is another commercial appeal which is 328 of 24, which is arising out of.
Number, ma'am, what is the number?
My lords, commercial AP 328 of 24.
328.
Of 24.
Where is it listed?
No, my lords, I pray for a short accommodation so that both the matters can be heard together.
Your Lordship, in respect of both the appeals, arbitration proceedings have been commenced and the arbitrator has passed an order under section 17.
Oh, the proceedings are pending.
Proceedings are pending before the honorable arbitrator and there has been a section 17 application and subsequent to the commercial court order, section 17 application has been allowed, Your Lordship. So
then what remains, ma'am? See, you should, now the arbitrator is in place. You should work out, this is section 9.
please, Your Lordship. If Your Lordship permit, I'll place the arbitrator's order.
He has passed a section 17. Who filed 17?
We filed.
And
Claimant.
granted.
It's allowed.
Then what remains, ma'am, this appeal? Is there any date in 328?
In my knowledge, I don't think there is a date, my lords.
Just check up, ma'am, 328. 328, 20, 10-7. Oh. So it's on 10-7. Very well, at the request of counsel for the appellant, list on 10-7.
Much obliged.
51 Arjun. 52. Shri Krishna Swami. 52.
I appear for the
I'm
respondent.
appearing for the appellant, my lord. My lord, my senior is not well, so seeking time, my lord. Any day next week.
At the request of counsel for
Respondent.
respondent, adjourn to.
An interim order may be extended, my lord. Interim order may be extended.
You have made the request.
He made this.
At the request of counsel for the appellant. IO to continue. Not continued. We will continue the interim order. You are the respondent?
Yes, my lords.
Sole respondent?
Yes.
See, there is an order of 13/12/24. In the meantime, there shall be no precipitative action.
Yes, yes, my lords. Now it is posted for admissions. Now it is posted for admissions, my lord. Interim order is in place, yes.
14-7.
Great.
Serial number 53. Shri Abhinay.
Much obliged, my lord.
53.
Looks like I appear for the appellant, my lords. Unless there's some pressing urgency in this, I'm being led by senior counsel, my lords. It may be passed over, my lords. A short passover and we'll go ahead.
Passover would be difficult, ma'am.
My lords, it may be had tomorrow, my lords.
What is the urgency?
My lords, in this matter, my lords, we've challenged the order of the Karnataka Real Estate Appellate Authority, my lords, which have produced at Annexure A, my lords. In that, we've placed certain questions of law that is on record in this rare appeal, my lords, before this honorable courts. There is a pressing urgency that an execution may be filed to execute the
Just
order
give
of.
it, ma'am, after 2 p.m. Give it 25, 26. At the request of counsel for the appellant, re-notify.
25-4.
20, great.
Say number 54.
I represent the appellant in this matter. We make one humble request, my lord. There is another writ appeal, 936 of 23, my lord, which is filed by the purchaser in both the matters, my lord. This is a PTCL matter. Purchaser is the same.
Are they connected?
My lord, they were heard and decided together. In the sense, two separate orders, but the purchaser in both the matters are the same. May I request, my lord, maybe link connected with writ appeal 936.
When is the matter coming?
It's not listed, my lord. The emergent notice has gone and there is an interim order. They have appeared. They have appeared and.
In the other matter?
Yes, ma'am. In the other matter.
What is the date?
There is no date given in that matter.
We will adjourn this matter. You get it listed along with this.
I'll file a memo in that matter.
Do that. What is the number there?
936. 936 of 23. Writ appeal.
At the request of counsel for the appellant, adjourn to.
There is an interim order pending, my lord, operating in this matter.
In this matter?
In this matter.
Interim order, if any. To continue.
Writ appeal 936.
Till the next date of hearing.
23.
15-7. $55.
Okay, for the appellant, my lords. There is a do not appear, my lords. This is the PTCL matter where, my lords, I was the respondent 4A, my lords. Notice was not served, my lords, but appeal writ petition was disposed of without hearing me, my lords. That is one of
Let's
the.
see this. Notice where? Which notice?
Was demised, my lords. LRs were brought on record as 4A. Page 29, my lords. Respondent number 4, Saumapa, was the grantee, my lords.
Yeah, but notice was served on you. Notice was served on you. You see the page 16. You were the original grantee or the.
Yes, my lords. I was the original grantee, my lords. Original grantee was.
Your predecessor in interest.
Yes, my lords. I was after his demise, my lords. LR were brought on record. Notice was not served on the LR, my lords. It was pending. Meantime, my lords, on the.
Sufficient.
Where is the plea taken before the learner single judge?
My lords, on the grounds, my lords, I have taken specifically, my lords, at.
You show us in the writ petition.
Notice to R4 is held sufficient. That is what it is.
Four and 4A. 4
Yes, my lords. My lords, that is the, it was not affected on me, my lords. That is the
How would you, where
contention.
do you
I
say
was
so?
not aware of the proceedings at all, as well as.
Where do you say so in your petition? In your appeal?
I have stated process fee and a separate case papers. Postal cover with postal stamps as required for the purpose of issue as summons to the LR4A. As could be seen from the order sheet.
You are
I'm his son.
When did she sold the land?
Well, the land was sold, my lords, in 1968, my lord.
1968. Now, who filed the writ petition?
My lords, the writ petition was filed by the subsequent purchasers, my lords.
Now, did you approach the land tribunal?
Yes, my lords. I had filed before the assistant commissioner as well as it was allowed, as well as DC confirmed it.
Did you file it before the assistant commissioner?
My lords, it was filed in
2006.
6, my lords.
So how many years? When was
24.
When was the sale deed executed?
Sale deed was executed on 1/6/1966, my lords.
In your favor?
No, that is
No.
Sagole 82, my lord.
82 is the sale deed alienation has
82
taken
and
place.
2005.
Respondent 5 to 7. What 5 to 7? 5 to 7 ये. Okay. और ये भाग्य लक्ष्मी कौन है? See, what is wrong with this order?
My lords, in fact, okay, only now the situation is that, my lords, now the writ petitioners, my lords, they are selling the property, my lords. The purchaser who is intent, he wants our parties to join as a confirming. There is a negotiations, everything is concluded. There is a conveyance where we are also joining with this one, my lords. Until that, my lords, it may be accommodated in the month of June, so that, my lords,
You will tell what is the right here.
the only right, my lords, that I was not heard. That is the only ground, my lords, I have
So
made.
that we can't accept it. Because the learned judge has noted also, you see page 16. For a notice to 4A held sufficient.
My lords, that is the one, my lords, the process was not paid. My lords, they filed, the petitioner files on a memo, my lords, that it notice has been served. On the basis of that memo, my lords, it's taken, but officially, my lords, there is a no such notice has been served on the respondent, my lord. That is my humble submission. From the records I have verified, and thereafterwards I've made the, making this statement, my lords.
The original grantee was Muniswampa.
Yes, my lord.
When did he expire? When did he expire?
My lords, he expired.
Yes.
That's expired on
When did he expire?
during 2013, my lords, because LR's application was filed, my lords, in 2013, where, my lords, in that they say that they came to know that,
See, come to page 155.
my lords, this is the memo which they have filed, my lords.
That's
that-
enough. You don't claim it. So what can they do? And we want to know when was the original grantee expired, the filing of the writ petition.
Please, my lords.
That's right.
Please.
So notice was there to him.
Please.
And later he was impleaded as a legal heir was impleaded.
Yes, my lord.
That's right.
Yes, my lord.
So
Amendment was carried in 2015. So maybe
After this, my lord,
it was carried out on 13/3/2015, my lord.
after this,
That Muni Swamappa was dead and 4A was brought on record.
after this memo, my lords, notice was once again issued to me, my lords. That notice never served on me, my lords. The petitioner says that this is the sufficient notice, and my lords, it was proceeded, my lords, without hearing. That is the only ground, my lords, I am urging. That's all, my lord.
what is your case even on merits?
My lords, with regard to the settled position of law, as this one, my lords, if I delay in the proceedings, my lords, it amounts to this one.
Law
There's
is
ignorance.
settled.
Please, my lords.
So then,
My lords, what had happened is in this matters, my lords, that when the first alienation had taken place, they had not affected the revenue records in their name at all, my lords. And petitioner being continued in the land. Only, my lords, in 2004-5, revenue records were transferred to the original, the purchasers in 1982 in their name, and immediately they sold to the respondent number 9 and 10, my lords. That time, my lords, coming to the transfer of the revenue records only, they came to know about the this one, and they filed the application before the assistant commissioner that there is a violation.
1982, you sold the land.
Please.
That's right.
Please, my lord.
Then thereafter, even 2005, there was a further sale deed.
Please, my lord. But revenue records, my lords, 1982, when they purchased, those revenue records were transferred only during 2004 and 5.
What difference it would make?
Please.
Sale deed has been effected. You
Please,
have
please.
sold it 82. Your subsequent purchaser sold it in 2005. And even thereafter, there was a further sale deed in 2008. And after 2008, you approached the assistant commissioner.
2006, we approached the assistant commissioner, my lords. He allowed the petition in 2008.
During the pendency of the proceedings also, it was a further sale deed was executed. And you see page 19, the Supreme Court is very clear on this, dealing with these provisions, these provisions of this act only. So we don't see any illegality. Effectively, the challenge is being made. 6, 26, and 26 and 8. After almost 44 years. See, 82 you sold. 24 years. 24 years. Difficult. Dismiss it. just say this, the challenge in this intra-court appeal is to an order dated 13 February 2020, passed by the learned single judge in writ petition number 18516-517 of 2013, whereby the learned single judge has allowed the writ petition filed by the respondents respondents 9 and 10 herein by stating in paragraph 7 and 8 as under. The undisputed facts are that the predecessor in interest of the appellant herein, was granted land bearing old survey number 1/P35, new number 86, measuring 1 acre 39 guntas, situated at Gondanahalli village. Just take it from here. In the year 1964-65. Saguvalli chit was issued on 1/6/1966 with a condition not to alienate the property. The original grantee was sold the land, had sold the said land in favor of predecessor of respondent number
4252. 4, my lords. 426.
4 to 6. 4 to 6 in this appeal. With a sale deed dated 25/10/1982. The respondents 4 to 6 had also sold the land in favor of respondent number 7 herein.
7 and 8, my lords.
7 and
8. Sale dated 31/8/2005.
No, 7, very well. 7 and 8. Not 7 and 8. 7 and 8 herein. With a sale deeds dated 31/8/2005 and 12/7/2007. It is noted that even respondent number 8 had also sold the land in favor of the respondents number
9 and 10.
9 and 10, who were the petitioners before the learned single judge. Full stop. The original grantee, that is predecessor in interest of the appellant, had approached the assistant commissioner under sections 4 and 5 of the Act. This is Karnataka schedule. Yes, put it that way. For resumption of the land in the year 2006. So the assistant commissioner, by order dated 27/6/2008, had allowed the application and held that the sale dated 25/10/1982 is contrary to the provisions of section 4(2) of the Act and resumed the land in favor of the original grantee. The respondents 9 and 10 being aggrieved by the order of the assistant commissioner had approached the deputy commissioners under section 5A of the Act. The deputy commissioner, by order dated 9/10/2012, dismissed the appeal, which resulted in the respondents 9 and 10 filing the aforesaid writ petition. The learned single judge has held that there was an inordinate delay of 24 years in invoking the provisions of the Act. In support of his conclusion, he has relied upon the judgment of the Supreme Court in Nekanti Ramalakshmi versus State of Karnataka and other 2018 1 Karnataka Law Report of 5 Supreme Court, wherein the Supreme Court has held, has inter-alia held that has held that an application for restoration made after 24 years could not have been allowed. First, we have already extracted the paragraph 8 of the judgment of the Supreme Court while reproducing paragraph 7 and 8 of the impugned order. Full stop. We agree with the said conclusion of the learned single judge. So we may note that in a writ appeal being 210 of so and so of a coordinate bench of this court, comma, in the case of M. Manjula and others versus the Deputy Commissioner, Bengaluru District and others, the coordinate bench had also on a similar identical issue, and also by referring to the amendments which have been brought to the Act, more specifically Section 5 thereof, has dismissed the appeal filed by the grantee. Filed by the legal heirs of the grantee, original grantee. It suffice to state that the appeal thereof has been dismissed by the Supreme Court with the order dated 1/4/25 in SLP civil number 8421 of 2025. If that be so, comma, we find no merit in the appeal, the same is dismissed, no cause. How much, ma'am? Additionally, just 1 minute. Additionally, we find there is a delay of 515 days in filing the appeal. Filing the appeal, so we dismiss the appeal both on merits and on limitation.
56 Sajjan. 57 Shamaresh.
But regarding settlement of disputes between.
Pardon?
Regarding settlement of disputes between public sector undertakings, but there is OM dated.
See, we should, and we firmly believe it should be taken up at the government level. Both are public sector under the government of India.
That's what, but the learned judge has read into.
Mr. Shetty, you are appearing?
For arbitratable, contesting respondent is different.
No, who is the contesting respondent?
I think
Mr.
BHEL.
Prakash. Is the Prakash?
Notify agidya.
Acha, notice has not
yet notified.
Notice has to.
And you must take it up. And the arbitration was under that permanent.
Yes, that should be melodies. But
area of arbitration.
The arbitration agreement melody did not contain the clause that is contained melody in the OM. Melody OM melody, the learned judge quotes that.
These would be inconsequential.
Totally.
Once maybe at the level of Secretary Industry or Secretary Telecom or the Cabinet Secretary, this need to be looked into. Between two public sectors, I think.
Well, there is no.
So There is a judgment of the Supreme Court in ONGC, you know, where between the public sector need to be settled. So what do you suggest? Shall we issue notice to BHEL?
Notice may be issued, my lord, we will. Yeah, for
we find that notice to respondent number 1.
first respondent.
And just show the last, the file. Ma'am. Did we issue notice? Notice to respondent number 1 has not been issued. Issue notice to respondent number 1, returnable long. Mr. Shetty appears for respondent number
2 and 3.
2
and 3.
2 and 3.
2 and 3.
14/7. Serial number 58, Shrikant.
What is this?
Lord, there is some delay, my lords, in preferring the appeal.
What is merit?
My lords, on merit, my lords, when I was appointed, my lord, the provisions of 1978 rules, my lord, that is Karnataka Private Education Institution Discipline Control Rules, my lords, it was holding the field. As per the rules, my lords, the appointment should be made, my lords, with publication in the newspaper, and my lords, calling for interview. My lords, in my case, it was done. And also, my lord, departmental officers were called, my lords, to the interview, but they did not attend, my lords, for whatever reason. My lords, when the matter,
how many years you put in?
My lords, I was appointed, my lords.
But there was no notification?
My lord, there was notification issued in the my lord, newspapers, in pursuance of which I applied.
Where is that notification?
Lords, your lords may kindly have look at, my lords. I don't know whether I have. I'm not sure whether, my lords, I have produced, my lords, the notification, my lords. But, my lord, it's a fact, my lords. In writ petition, my lord, it was not produced, but it formed part of the records, my lord, before the authority, divisional authority, my lords.
But where is that? We want to see that.
Please, my lord.
We want to see that notification.
My lord, that
how, in what manner they had issued it. Now tell us one thing, please. Were there other applicants also other than you?
Lord, that instruction.
Or you were the only candidate?
Lord, that instruction, Lord, I do not have. But what has been informed is that, my lords, he applied, and my lords got selected.
How many appeared before the selection committee?
Lord, at that time, my lords, that is in 1997. My lords, I'm not very sure, my lords, as to how. My lord, that instruction, my lords, I can secure.
That need to be seen.
Please.
They may not have appeared. The government officers doesn't come. They are part of that selection committee.
Lord, they are. Lord, in fact, my lord,
and mind it, that becomes important because this is a grant in aid post.
My lord,
right?
In fact, my lords, as on that day, my lords, there was no concept of prior permission. In spite of that, my lords, they were my lord, asked to be a part of the selection committee.
But one thing,
please,
there are judgments.
Please.
If a person sits in the selection committee of the government, he's sitting in that capacity only. That doesn't mean he's sitting there approving or accepting the appointment of a person would be an appointment.
I'm afraid, my lord, I beg to differ with that. My lord, year 2001 SC 2836. Yeah. My lord, in Lakshman Dundappa Damneka's case, the matter went, my lord, to Honorable Supreme Court from this Honorable Court, where, my lord's, departmental nominee was present during the course of my lord selection. And the Honorable Supreme Court, my lord, holds in such circumstances, an approval is not necessary.
Who has to approve it?
My lord, the officing it. Not necessarily. His nominee will be there.
Nominee would be there. That
Please.
doesn't,
Please.
that law is also there. That doesn't mean that that's an approval of that ultimate authority.
But my lord, the Honorable
Very
Supreme
well.
Court says it is not necessary at all, my lord.
Which year is that?
2001 SC 283 is pertaining to the same rules, my lords.
Law is clear. He is wearing two hats. One as a nominee and the other one is an approving authority.
My lords, what I am trying to say is, my lords, he was called for, I mean, the objection which is raised is that without taking permission, my lords, of the authority, we filled up the vacancy. My lord, that was not the law, my lords, as on that day in 1997. 99, my lords, the rules were framed, and my lords, the new rules, my lords, came into being. As per that, my lords, we had to take, my lord, specific prior permission.
So, you file the notification.
Please.
Okay. And possibly information, how many candidates had applied?
Please.
Did they participate in the selection committee?
Please.
You may argue that this is not your fault, they had not come. How many completed?
Till 2010, my lords, almost 12, 13 years.
13 years. Okay, you're still working now. There is no stay order. There is no protection.
No, my lords.
Who appears for the others? Ma'am, you appear for the state?
Yes, my lord. My lord, this
Who
has.
appears for the school?
My lords, Vijay.
Hmm?
In fact, they took time, my lords, saying that they will file objections to the application.
And who is this respondent number 7?
My lords, who was selected, my lords, and appointed subsequently.
After your services were terminated,
My lord, they issued, my lords, paper.
Fresh notification.
They called for, my lords, selection. In that she was appointed. Case is that my lords, I did not participate.
My lord, he is lost in the appeal, the revision,
That doesn't mean that, my lords, I don't have a
and
case.
the learned single judge in para 4, my lord. Didn't even participate in the selection process.
Need not. That is the second selection process. Why, my lords, I was already appointed there.
where are the rules of that time?
My lords, the Karnataka Private Educational
At
Institution.
that time, at the relevant time, where you say there is no approval is required. That's your submission?
It says, my lords, when the rules prescribe departmental nominee to be a part of, my lord, the selection committee. The rule says if he is part of it, the judgment says, if he is part of it, then no approval is required. Here, my lords, he was called for. My lords, they did not appear. But the objection taken is I did not take permission. Such concept was not there, my lords.
Where are the rules?
Lords, rules.
Mr. Srikanth.
Please, I'm sorry, I'm extremely
On
sorry.
record, everything.
Please.
My lord, if your lordships looks into the revision petition at page 196, all these arguments have been examined and looked into.
Ma'am, what is this 156, ma'am?
196, sorry.
No, just come to 166 or 156.
That is subsequent notification, my lord, which has been.
This subsequent.
Please.
You said 196.
Please, my lord, that is the order in the revision petition.
The proposal was also submitted to the government.
No, that was of the second selection, which they, my lords, appointed in my place. They, my lords, called for interview and they submitted that proposal, my lords, for consideration to the department. That's why, my lords, I was constrained to file the petition.
Just see, let's see the reasoning of the single judge, please.
Para 4 onwards, my lord.
Para 5, my lords, is what the learned single judge, my lords, records.
But tell us one thing, even the school is opposing it.
That's why, my lords, I was constrained to 5, my lords. Otherwise, my lords, if the school was, my lords, supporting me, lords.
So it's their understanding also. But the only thing you can argue is this.
Please.
If school was so clear that it was not an appointment, proper appointment, why did they continue you for 13 years? That's right. They had only continued. And see, that's more reason. Please. It's a grant in aid post. Please. Yes or no?
Yes. Yes.
That's more reason that the approval must be there.
Lords, in fact, no, my case is that it was sent. Your lordship,
then you will not argue it was not required at the relevant time. Then you will not argue that.
My lords, I would still, my lords, would say, because my lords, that is only on one ground, that my lords, they were asked to come. They chose not to come. In such circumstances, my lords, my humble submission would be that, my lords, when they themselves, my lord, they don't appear, my lords, in the selection process.
No,
later on, my lords, they cannot say that it is not.
Let's be with that.
Please.
Very well. But even assuming for a moment,
please,
approval was required.
Please.
And even they were present in the selection committee.
Please.
Still, it would have gone for approval.
That is not necessary, my lords, is what I am trying to, my lords, submit.
Where is the case set up in the court below, before the authorities?
Lords,
where is the revision petition 196?
Please. The petition copy, my lords, the difficulty, my lords, writ petition was handled by, my lords. I'll place it on record, my lords. I'll place, my lords, all the documents, my lords.
The request of Mr. Shrikant to place on record the rules and the notification issued for calling the applications for the post of, what is the post?
My lords, assistant teacher, science.
Master.
Yeah, assistant master.
Assistant master.
PCM, my lords. Science, PCM, my lord. Physics, chemistry, mathematics.
Assistant master, PCM. Re-notify.
37.
Published.
59. Pradeep Savkar.
Appearing for the respondent, my lord.
My lords, I appear for the appellant in this matter. My lords, arguing counsel for this matter, my lords, had to undertake travel. My lords, I request for a short accommodation in the matter. Any date next week, my lords.
My lord, if I may make one submission, my lord. I have filed my objections to their continuation of delay application, my lord. Notwithstanding my objections, I mean, your lordship signs may condone the delay. But my lord, I may be permitted to file my objections, my lords, on the main petition, which I will do in the next couple of weeks, my lord.
But this is against a single judge, no?
Please, my lord.
Please, my lords.
You are for the respondent.
Please, my lord.
This charge is the sanctioning of loans.
No, my lord. There has been some issue about, there have been 2 charges that have been framed, my lord, regarding misappropriation of money. Fact of the matter, my lord, is that there has been no misappropriation. There is a trial that has been conducted, and the my lord, the respondent has been acquitted, honorably acquitted as well, my lord.
In the criminal case?
Please, my lord.
Just show us that. You have the judgment of the criminal case.
Please, my lord, it's there in the second. one.
Shows.
Annexure R, my lord. Madam.
417 page.
Yes, 479.
Now today you are getting pension?
No, my lord.
Why?
My lord, I've been terminated from my services, my lord, as of.
They have not implemented it. But on the strength of the learner single judge order, would you be entitled to pension?
Please, my lord, I would be, my lord.
Which page you are reading?
479 onwards is the judgment of
Page.
the trial court, my lord, of the learned magistrate. At page 485, my lord, at the end of page 484 and page 485, my lord, categorically states, my lord, under these circumstances, prosecution failed to prove the guilt of the accused beyond reasonable doubt. In the absence of any legal and acceptable evidence, the accused is entitled to be acquitted.
At the request of counsel for the appellant re-notify. Ma'am, just
15-7.
run through faster.
Till number 60.
Obliged, my lord.
I appeal for the appellant, my lord.
I appear for the respondent. my lord.
This may kindly be taken up tomorrow, my lord. Tomorrow or day after tomorrow.
What is the urgency?
Urgency is not there.
Maybe taken
Because
up
here,
after
my lord,
admission.
the punishment of dismissal was imposed by the disciplinary authority and it has been conferred by the appellate authority. That learned single judge has modified the punishment to compulsory retirement on some extraneous reasons, sympathetic and all, my lord. That is why this repetition is on the basis of the FS court. Similar cases, the FS court said it is not correct.
We will hear it.
Yes, my lord.
Please.
Just say that re-notify on.
18-7.
Obliged.
61. Shri Shankara Gowda.
Lords, I appear for the appellant in this matter, my lords.
Yes.
This is the matter which I mentioned in the morning.
61.
You mentioned in the morning.
I mentioned in the morning, my lord.
Just say that at the request for respondent number 4.
Yes.
At the request of counsel for respondent number 4 in WA 223 of 24 adjourned.
18-7.
Village judgment.
62 urgent. 63. Serial number 63.
My lord, I appear for the respondent number 1, Union of India, my lords.
My lord,
Yes.
this matter, my lord, appellants are the doctors in the radiology department. And
So the issue is pending now.
in Supreme Court, my
What
lord,
happened?
my lord, is
Exactly.
still pending, not completed. While this being the case, the writ petition filed by us, another association back in 2013, that got dismissed for non-prosecution when the matter was transferred. Not realizing the matter was transferred, the matter got dismissed for non-prosecution.
There in Supreme
No,
Court.
my lord, from Karnataka High Court
To
The writ petition was filed here in Karnataka.
But where?
To Supreme Court, my lord.
So when was it dismissed? Was it dismissed here for non-prosecution?
Yes, my lord.
But how can that be transferred now once it was dismissed?
Yes, my lord. That's the point, my lord.
But in any case, the matter went there.
Yes, my lord.
The record went there.
Yes, my lord. Well, that being the case, here the WP got dismissed, and we challenge another association challenged the same amendment, and that was also dismissed. And on that aggrieved order, single judge bench order, we filed this writ appeal. Meanwhile, there were other writ petitions filed in this before this Honorable High Court, where the stays are granted to individual parties. And the Karnataka government, which issued the notification, they have withdrawn that notification also now, recently, my lord, 2025.
What is the notification for?
My lord, the notification is the earlier 2013 writ petition. On that basis, on the dismissal basis, a notification was passed, where in one district, a radiologist cannot operate, or which translation of that?
My lords, the appellants haven't filed for a recall of the dismissal at all, my lords.
Notification is being issued.
But what is the error in the order of the learned single judge?
My lord, when the petition was transferred, and in the similar matters, there were interim stay was granted to others. As an association, I was before the single judge, my lord, not taking into account where the matters which are transferred.
He has also taken into account the matter is pending before Supreme Court.
True, my lord.
The issue would be decided there.
True, my lord.
Then,
however, as an association, only two doctors in state of Karnataka gives protection. As an association which has more than 100 doctors, radiologists.
What happens? Supreme Court still pending?
Yes, my lord.
And why don't you go there also?
My lord, if the matter gets transferred, I am willing, my lord. One matter which is already association is
Same
gone.
association.
Yes, my lord. It's a different association. My lord.
My
Because
lords,
today we are not
they have
protected
not
as
filed for a recall of the order
Same.
that dismissed this matter for non-prosecution before the Karnataka High Court, my lords. So therefore, therefore that has not been recalled. They could very well recall it and have themselves appear before the Supreme Court. At this point, my lords, the judgment, the single judge has just stated that since the matters are pending before Supreme Court, this petitioner may also approach the Supreme Court, and that seems right and fair, my lords.
See, appropriate shall be when the issue is pending before Supreme Court.
My lord, I bow down, my
The
lord.
matters are, getting transferred. The Supreme Court is transferring all the matters to itself. This appeal should not. You must go there.
Well, my lord, this writ petition, after my writ petition got dismissed, there came to be another writ petition filed here only, and the stay is granted, my lord.
So you want us to follow the same?
My lord, only if
The matter is pending before the Supreme Court?
my lord, till then I be protected. Let that be adjudicated, my lord. That's all. Right? Whatever is
Here or there?
my lord, what will be followed from there? I mean, here we will follow that.
Right. So see,
My lord,
that's the reason. And it appears that the single judge has actually gone. It's not a case where the matters were not getting transferred to Supreme Court. The matters were getting transferred to the Supreme Court. Either you had an option, file an application for transfer there, so that the Supreme Court call for this appeal
Well,
also.
not at my behest, my lord. It was the union government, central government. It had sought for transfer. Well, that's so, my lord. Me being here and they sought, and I get dismissed, and I've been told to no, we will not. We go before Supreme Court. And while other petitions get
My lords,
entertained and
my
individual
learned friend was not, his writ petition was not in existence at the time that the other matters were transferred, my lords. He's most welcome to approach the Supreme Court now to seek his relief and to be clubbed along with the other matters.
Which matter was dismissed for non-prosecution?
My lord, it is at page number.
But not 22207, no?
No, my lords. This came to be only in 2023, 22207, my lords.
Page
Which is
number,
being appealed before your lordships.
153, my lord. Sorry, my lord. 157. It's operating part.
Did you seek the restoration?
No, my lord. The other association approached the writ petition by through writ
It was
petition.
not even this association, my lords.
My lord, wait, that being the case, my lord, here the state now who has passed the notifications, they have withdrawn their own notification, my lord.
Whatever is the effect, we don't say anything.
My lord, in that effect, I may be protected, my lord. At this,
Today, the learner single's determination is only this. The matter is pending there and liberty has been granted to you.
my lord, it is while I am being in the High Court, my lord, affected party, me being, for the matter, there are matters are pending and adjudicated.
Appropriate should be there when the matter is pending.
No,
before
no
the
doubt, my
Supreme
lord. I
Court.
am not insisting for a final order, my lord. I am only seeking an interim order. When that matter gets adjudicated, I'll follow that order.
Very well. It's
Invariably.
For you to take a call. You want to go to Supreme Court, what do you want to do? We say nothing. See, propriety demands, when the matter is pending there, should be. How can that be? We pass an interim order and the matter will await for
My
that.
lord, not at that point of time, my lord.
Maybe, it's all right. And when was the impugned order passed?
My lord, the impugned order in my matter was passed in 7th December 2023. 7th December 2023.
More than a year has gone by.
Please, my lords.
Here,
You could have possibly got an interim order from the Supreme Court.
my lord, that matter which is transferred, all the matters from all the other states have not been taken up, my lord.
Fine.
My lord, I only seek interim protection, my lord, that's all. While, my lord, your lordship may consider
Matter is pending there.
my lord, the notification in which the writ petition was filed, that notification itself is withdrawn by the state, my lord.
So what follows? What is the effect? Effect, it is not binding on you, or you can practice, or you can go to whatever is the purport of that notification. The effect thereof has been taken away
Yes, my lord.
in your favor.
Yes, my lord.
Then what remains in this appeal?
But till the matter is finalized, I may be in the Supreme Court, my lord, because the matter was
You
transferred.
can't contend both. If the notification has been taken away, has been withdrawn,
Yes, ma'am.
a consequence flows in your favor.
Yes, ma'am.
That's why then where is the grievance now? We say nothing. We are not saying, we are only observing what you have said.
My lord, that was a development later to the impugned orders were passed, my lord.
Today that
Yes,
position
yes,
exists,
yes,
it
ma'am.
doesn't exist. Today any cause exists for you to file a writ petition?
No, my lord.
Where is the question of stay then?
The matter may kindly be disposed, my lords.
After this order, you
Supreme,
want to withdraw this appeal?
no, my lord. Matter may be transferred to Supreme Court, this
Who?
matter.
What is the order of the learner single judge?
To go before the Supreme Court only, my lord.
That's right, that stands. If you withdraw it, that order would remain.
I'll just seek.
It shows the file.
Page number 23, my lord.
These are not, these are which are already transferred pending consideration. Therefore, the petition is not. There is a remedy, liberty granted to you to avail such remedy as available in law in the light of aforesaid. Withdraw it, whatever you want to go do it
I'll seek one date, my lord. I'll take instructions on this.
tomorrow.
Obliged.
The request of counsel for the appellant, re-notify tomorrow.
22.
Much obliged.
Just run.
Serial number 64.
My lord, time for appellant, my lord. Short inconvenience on his legs, my lord.
Re-notify on.
18/7.
Obliged.
65.
The appellant, my lords. The appellant, my lords. Lordship, kindly.
Respondent. Have it some other day, huh? Just say re-notify on.
9/7.
I kindly request any date in June, my lords, if it is possible.
It's a simple matter.
Because
Could have been.
very short point.
Just even July.
Please.
17/6.
Obliged, my lord.
66 urgent. 67 Shri Mali Patil. 67.
Disposed of the writ petitions, but in terms of the order passed in WP number 22621 of 2021. Against which, my lord, writ appeals have been filed by the state government as well as by me, my lord. It may be tagged on to that. My lord.
276 of 24 and 446 of 24. That is absorption.
No, that's correct, my lord. They are not, they are still working.
What is the date in those matters?
This is regarding, my lord, absorption of, my lord, the contract employees.
What is the date in those appeals?
Sorry, my lord.
The date in those appeals.
I think, my lord, the date has not been. We are
Those
not aware of
appeals, my
this.
lord,
Next. Lordship may say tagged along with those matters.
those appeals papers are not available with me, my lord. Maybe called, my lord, along with that.
The last week, my lord.
We'll do
And
one
there's
thing,
no
we
interim
will,
order, my lord, in both.
we will just adjourn this appeal. If there is no date in those appeals, get those appeals listed on this date along with this appeal.
We will furnish the date, please. Furnish the date to the court of.
My lord,
Just say that-
Put in the-
Order, my lord, is here, my lord.
Re-notify on.
Page number, my lord.
We got it, but there is no date in those appeals. Oh, tomorrow? Oh, we'll have it tomorrow. It's tomorrow. Ma'am, ma'am, here only?
Along with those the appeals, my lord.
Tomorrow. They are coming here tomorrow. Re-notify tomorrow.
68.
Lord, in this case, I appear for the respondent number 13. I have filed Wakala, but in the cause list, serial number 3 is showing.
You're Mr. Naveen Kumar.
Please,
You have filed for 13.
13.
Mr. Naveen Kumar, advocate who has filed wakalat for respondent number 13, states that his name be shown in the cause list as the counsel for respondent number 13. The registry to act accordingly. Next.
Please.
68. Kulkarni.
Happy for respond number 1.
Happy for the appellant. My lord, there is a delay of 160 days in filing an appeal. My lord, the facts of the case are, my lord, the second respondent regarding allotment of the sites. But the second respondent here made an application for allotment of a site. First, he had made an attempt for application measuring 40 by 60. Then she did not get the site. Then she made an application for measuring 50 by into 80 sites for 2 attempts. Totally, she has made 3 attempts. As per the notification, she has to make an attempt for 3 attempts for the same dimension. And her date of birth should be, my lord, prior to the date fixed in the notification, that is in 69. Her date of birth was in 1971. She had no minimum qualification for the file an application for allotment of a site. However, she managed to get the site in her favor. Then, my lord, after noticing the said fact, BDA, my lord, issued a notice and cancelled the, my lord, the allotment. That was challenged in the, my lord, before this honorable court in a writ petition. Since she was not heard, the matter was set aside and the matter was remanded by the learned single judge, directing them to, my lord, to issue a fresh notice and hear them. Then, my lord, after the remand, then once more notice was issued, and my lord, she was heard, and then the allotment was cancelled. My lord, subsequently, my lord, I was not aware of these facts, and I have been allotted a site, the same site to me, and a register sale deed has been, my lord, executed in my favor. My lord, the learned judge, my lord, again says, my lord, and remands the matter. My humble submission would be, my lord, once it has been remanded, the second this order has been passed. Admittedly, she has no eligibility at all. Under these circumstances, my lord, the order of the remand of the learned single judge on the ground that she has not suppressed the fact in her application is erroneous. It is not a suppression of the fact. It is by mistake.
When were you allotted?
My lord, I was allotted in the site on 21/1/20.
After the impugned order?
After the first impugned order.
First,
During the pendency of the petition. I'm sorry, my lord.
during the pendency of
Pendency of the
Yes, yes.
That's one submission, my lord.
But tell us one thing, how would you be aggrieved by that order of remand? Were you the party there before the learned single judge?
No, first time I was not a party.
Second time?
Second time I was a party.
When the remand was made?
Made, yes.
So very well.
That's one submission.
But she had no eligibility at all.
That's a different argument. They may agree with you. They may agree with you. And was any right given to you to appear also before the authorities?
No, I was.
We heard.
No, I was not.
One submission, my lord. My lord, if your lordship kindly peruse the order of the honorable single judge, my lord.
the order, my lords, allotting the site in favor of the appellant, my lord, was also set aside by the impugned order. My lords, pursuant to the order passed by the learned single judge on 6/10/2023, my lord, whereby his allotment was cancelled, my lord, he makes a request before the BDA, my lord, to execute sale deed, my lords, in his favor. My lord, after the allotment itself was cancelled by the honorable single judge, my lord, his request is considered, my lord, by the BDA in the month of November 2023, my lord, and sale deed is also, my lord, executed in favor of the appellant, my lord, in the month of December 2023. This appeal is filed, my lord, in the month of April 2024, my lords. There is a delay application also filed, my lord, along with the appeal. My lords,
Now, it is, today it's in your favor, the land.
No,
the
my lord,
plot.
the learned judge my lord, makes an observation. So far, the two conditions are there regarding the allotment of the site. One is my lord, there must be 3 attempts to be made for the allotment of the site. My lord, so far for the allotment of the site is concerned, 3 attempts should be of the equal dimensions. But the first time, she had made an application for my lord, the smaller dimension. But under the rule 13(2), my lord, that cannot be taken into consideration for considering the number of attempts. My lord, that aspect has been noticed by the learned single judge. And again, my lord, he remarks it. My lord, as on the date of my lord, her date of birth was 1971. So far as the date of the eligibility is, she must be born prior to 69. Both the conditions, it did not follow the conditions. Well, a learned judge, my lord, proceeds on the basis she had not suppressed the material fact. My lord, it is erroneous, my lord. The question of my lord, the eligibility has been considered by the allotment is not a question of suppression of material fact. She was managed to get a site.
I'm aware for the BDA, my lord. My lord, we have also filed the writ appeal, my lord. Kindly connect along with, taken along with.
You have also filed.
We have also filed, my lord. Writ appeal number 662 of 2024, my lord.
What is the number?
662 of 24.
What is the date? The counsel appearing for the BDA states that even the BDA has filed a writ appeal challenging the same impugned order, which is subject matter of this writ appeal. So if that be so, comma 662. It's in non-compliance stage.
it is not
It's complied.
I think we will adjourn it.
It's complied.
Compliances and get it listed here on that day.
It's complied.
Also states the interview listed on the list. So we give it appropriate to adjourn the interview to get that interview, do your objections on this day.
16/7. 69, Raghavan.
Let's appear for the response. Let appear for the appellant, respondent, my lord, sorry. Well, a delay of 9 days is there, it could be condoned.
Twenty 21/7, 70.
Appear for the respondents.
21/7, 70. Serial number 1, passed over matter.
My
lords, my submission is that the detainee is there in detention center. He has not been provided basic facilities. He has been locked for 24/7 since the date of his admission there. And this petition, this habeas corpus is filed in view of the order which was made for deportation, my lords. And after the order, after 2 months of the order, a appeal has been filed. That appeal is admitted. Now this honorable court may kindly dispose of the writ petition by directing the prisoner, the authorities, detention authorities, that he has been locked for 24/7. He has not been given basic facilities, other foreign prisoners, foreigners, my lords. And liberty may be granted after I will file an honor. Yes, my lords. Yes, my lord. That is the not to, because after facilities, all the prisoners, all the foreigners are getting the facilities of cooking, and they have been unlocked. They can move around, but he has been isolated for 24/7 since the date of his detention, my lords. And even in the month of Ramadan also has not been. Appeal I have filed, my lords. Here, appeal is. Yes, my lord. Still, the state has not provided a copy for us. The appeal has been filed 3 months earlier, my lords. The detainee is from 5 months, my lords. And after the appeal, there is an order, specific order. No, my lords. It is now I'm making my submission, my lords. In the last date of hearing, I have not been permitted to take a signature on the wakalat. That is the reason I filed a memo for appearance. And the detainee is willing to appear before the VC and make his submission, my lords.
(25/4). Serial number 7.
Public.
7. (23/4). 21.
My lord, serial number 21. I appear for appellant, my lord. My lord, identical matters is posted on 24/6, my lord. Kindly have it on same day, my lord. Please, my lord.
37.
Grateful, my lord.
Serial number 37. Should wait for it.
I pay for the respondent, not my apologies. But I have filed an application not for withdrawal of this amount which is in deposit. But I am the developer. But I have completed the work. But I had filed a suit not for specific performance, not to execute a registered sale deed. That is a registered joint development agreement, not, and also for recovery of a certain amount of money, that is 5 crores plus interest. But interim order was granted, and as against which not they have filed this appeal, and not they have made a statement that they have deposited 5 crores. But I'm saying not I may be permitted to withdraw. I'm ready to even furnish security, not.
I filed my objections to the application. What had happened, my lords, in 2016, my lords, I had entered into the JDA with the respondent. He was supposed to complete it within 2 years.
Lord,
He's giving
there
a
is
bank
25
guarantee, no difficulty.
No, there's not 25,000 square feet of area in the very land, not which is supposed to be allotted to me. That land itself not is valued of more than 5 crores, but I'll keep that as security. No difficulty. It is a land which is subject matter of development. There's no difficulty. Bank guarantee, my lord. But my bank guarantee, the difficulty will be not my amount will get stuck. But this very property, not I have not that extent.
It's
because
my property,
my
is saying it will pledge it to me only.
Lord, my difficulty is only this, Lord. This is a refundable deposit even according to them. But it is not their case that this amount which they have deposited is not a refundable deposit. It is even according to their own case, this 5 crores is a refundable deposit which is to be given to me. Therefore, Lord, I am only saying, Lord, I have some difficulty now because what has happened is, Lord, despite completion of the work, but they are not coming forward to execute a sharing agreement. So my money, my lord, I am asking back. It is refundable. There is no dispute on that.
My lord, the refund is subject to him completing the work.
Lord, can I make one
it
request?
has to be
Lord?
heard, my lord.
Lord, can I make one? Lord, now, Lord, they have obtained an interim order at the hands of the dishonorable court. Lord, the interim order that was granted not by the trial court was that they shall not proceed with alienation of the property, but without including me. Now, Lord, if they now not taking advantage of this, not alienate the property, that is another apprehension that they have.
My lords may record my statement. My clients will not alienate any property subject to till the disposal
Lords
of
may
the suit.
Record it, Lord, so that
Very well.
my interest is protected.
So far as his portion of 35% is concerned.
There the difficulty is not. Now what happens is there is no sharing agreement, which is his portion, which is my portion has to be earmarked, not, and thereafter only not he can sell it. He cannot sell anything, not. He does not want not to give me my share.
10 acres, my
Not
lords.
about 10 acres of land.
My lords, no, my lords, we will not.
25 acres not is total extent of land. No, Lord.
My lords may take the development agreement. In terms of the development agreement itself, it is only 10 acres.
Scheduled property itself, not this 24 acres, 12 gunta, so roughly about 25 acres. Yes, not. No, because what has happened is not trial court granted an order of injunction. But the dishonorable court granted, but the trial court order not says, right, page 22, the order not is to the effect that not, he shall not day after tomorrow, Lord.
The dates would be given. Just give me the date. The others, the dates would be given.
Sir,
Yes.
so case number 95, sir. I am party in person, sir. I filed my objections also.
My lord.
7-1. Is there spend? He misleads the 95.
Lord, one submission, my lord.
Serial number.
Yes.
Serial number 92, there is objection, my lord.
Yes, one.
Serial number 95.
Yes, what do you say? You are which respondent?
92, my lord.
Respond number 3.
Yes, 1 minute, please.
Respond number 3. 14%.
Yes. So what, you are there?
Is there?
Plus copy is not served, plus whatever the application
Who
is
appears
filed.
for the other respondents?
Plus government is appearing.
I'm happy to immediately after vacation. Just say that. We'll give you immediately after vacation.
My lord, may
Please
make
give
one
me your
submission.
response.
My lord,
Plus interim order may be extended.
Wherever interim order is there, just extend it.
my lord, may I make one submission. My lord?
Yes.
Serial number
Serial number
19, where
92, my lord.
H. Raghavan was appeared, my lord, last time. My lord, the matter, we are ready to deposit 1 crore rupees and we'll deposit by tomorrow itself.
I appear.
Yes, we will hear you.
But
Who
please,
is the other side in your matter?
he is there.
Lord. in
23rd, there is an execution. That is
There
why.
is more than 50 crores pending, my lord. They have not paid any money and they're not paying.
My lord,
rent
we will
also,
hear
my
you.
lord.
My lord,
Just
one
give it.
submission, my lord. 23rd is
My lord,
the
one-
execution, my lord. It becomes a
Lord, they have not
possession
complied
was
with the orders.
ordered. We are the tenant, my lord. That is why. My lord,
We have to hear you.
My lord,
We'll
serial
hear you.
number 100, my lord. My lord, I am the appellant, my lord.
In which
Supposed-
matter?
Serial number 100, my lord.
Yes.
My lord, I have, the DD is ready, my lord. I am supposed
will
to
come,
pay.
we will
it.
give
My lord, one
23rd, it may be
submission.
had it, my lord.
My lord, just one submission, I'm sorry, I'm really sorry. Serial number 96, my lord, it's listed for final hearing, but we as respondent number 4, serial number 96 is a batch of matters, my lord.
Yes.
It is with regard to mismanagement of funds of the government, and we have filed our vacating application of stay, which is granted on 12/1/24. So, my lord, if this matter may be listed in, for hearing on IA,
Which
any
IM?
date.
Which IM, ma'am?
Vacating of stay application has been filed on the 19th, that is the Saturday.
Ma'am, we will take it after vacation only.
Please,
Possible.
after vacation.
But
after-
we'll give you a date, the others will not give you.
Let it,
Have it on
my
29th,
only-
my lord. At least date may be given.
My only submission in the case is that because we have filed an IA, if it could come in hearing of IA instead of final hearing, it's been listed under final hearing.
You can press that IA on that day. What is the difficulty? You say you have filed a press.
Please.
We'll look
My
into
lord,
it.
at least have it, my lord, 29th.
Serial number 92, my lord.
Please.
92.
My lord, my lord,
This
my
one.
lord,
Just give it.
serial number 100, my lord.
It's all
My
right.
lord,
Please,
kindly
we'll
allow
have
me-
it. We have to go.
Please.
Thank you. Ma'am, is 92 is there? Just give it a date.
My lord, serial.
Great, madam.
Madam, serial number 96 ಅಲ್ಲಿ.
Court officer, court officer 92, sir.
92
Court
ಏನು
officer
ಹೇಳಿ
92 ಸ್ವಲ್ಪ ಹತ್ರ ಸರ್ ಜೂನ್ ನಲ್ಲಿ.
ಸರ್ 24/6 ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
Sir,
92
court officer 92.
24/6
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್
Sir,
ನಂಬರ್
ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಹತ್ರ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಡೇಟ್ ಹೇಳಿದ್ದೀರಾ ಕೋರ್ಟ್ ಆಫೀಸರ್